Good morning, everybody. Happy Super Friday. Welcome to TCF Live. My name is Dan Soul. I will guide you on this 3-hour journey through Courtlandia, starting with Magistrate Chisholm.
16th of May, about 5:25 in the morning, in the area of Royal Oak near Interstate 696 and Woodward Avenue. Ms. Patton, I don't see your camera. There you go.
Okay.
You've got three options this morning. You can admit responsibility for the civil infraction of careless driving. You can deny responsibility, or you can admit responsibility with an explanation. How do you wish to proceed?
I'd like to deny responsibility.
If you raise your right hands, please, to take the oath. Do you swear or affirm that the testimony you are about to give in this matter will be the truth?
Yes.
Yes.
I'd ask the trooper to testify first, please.
Okay. On the date of May 16th, 2026, on West 96 and Woodward Ave, I did get the time wrong in that citation. I will put that. But it was about a few hours earlier. I was on an initial traffic stop in the Gore right there on westbound 696 and Woodward when the construction was and the exit lane open. While trying to enter my patrol vehicle, a Chevy Black Malibu driven by Miss Patton failed to yield over, causing me to run to the middle of the freeway to make sure I wasn't hit by her vehicle. I then turned around, ran back to my patrol car, and initiated a traffic stop for careless driving.
Did you have your emergency lights on?
Yes, sir.
Ms. Patton, it's your turn, ma'am.
So when I saw the patrol car pulled over, there were initially two vehicles in the left lane, and I was waiting to get over into that lane. So I didn't press on the brakes. I let off the gas. And when they had passed, I was trying to see where the officer was located. And it seemed like he thought I was going to hit him. So I stayed where I was because I saw him. I mean, it was really dark, so I saw him run out into the road. So I stayed in the lane and slammed on my brakes, already getting ready to pull over before he turned his lights on to initiate my traffic stop. Because I was overwhelmed because he just ran out into the middle of the expressway.
All right. I think careless driving can be accurately described as driving in such a manner as to make it likely or probable that somebody's going to get hurt or something's going to get broken. In this case, there's a statutory duty to either significantly reduce your speed and or change lanes away from the position of a emergency vehicle. And the trooper has cited you for careless driving, and that's actually less severe than he could have cited you for. What you did could have been charged as a misdemeanor. The driver's responsibility is to know what's happening around them. The emergency vehicle on the street is visible for an extreme distance. The red lights, the blue lights flashing can be seen from far off. The light bounces off the sides of the vertically walled expressway so that they actually show on both sides of the expressway. And there's a human being there who has to dodge a car that's going to hit him. I don't think there's any ambiguity here, ma'am.
Okay.
The civil infraction is something for which you are responsible. The fine is $240. It can be paid online or by mail, or you can pay it at the courthouse counter if you prefer. Thank you. We're done. And that there is no one else in the waiting room yet, but they're not really late yet because it's only about 1 minute past the time they're supposed to be there.
Well, we're not going to stick around while you wait for somebody to get in your waiting room. Good morning once again, everybody. TCF Live on a Super Friday. Good to have you here. Let's stay in Michigan. We'll go to Kent County. Judge Rossi.
Yost, case number 26-01157-FH, and this hearing is being recorded on Zoom and live streamed on YouTube.
And Mr. Yost is before the court this morning for arraignment on a alleged violation of probation. However, I understand that that violation is going to be dismissed at this time, so I'll let probation lead us off. Agent Sanders.
Good morning. Thank you, Your Honor. Agent Sanders on the behalf of Kent County Probation. Yes, that's correct. Mr. Yost was sentenced on June 11th, and after confirming from his jail status following, it looks like he went to Ionia County Jail on June 12th, and then was transferred on the 15th to Montcalm County Jail until July the 22nd. So after confirming his status, yes, that's correct. We recommend no violations at this time, and that the defendant be released from custody and continue on with probation.
All right, and my understanding is my order envisions him going to alternative directions. Is he to be released directly to alternative directions, or do you want me to release and have him report to you and then AD?
Yes, if you could, Your Honor, have him report to me. We'll still have to complete the initial orientation, and then we'll get the ball rolling with alternative directions.
Very well. All right, Ms. Bama, why don't you place your appearance on the record?
Rachel Bama on behalf of Mr. Yost.
Very good, and that's all consistent with your understanding of the situation, Ms. Bama.
Yes, just for the record, I feel bad for Mr. Yost because he was in custody. This violation shouldn't have been filed, to be honest. So I hope that probation is more careful in the future to check if someone's in custody.
Well, and of course, when someone's in custody in multiple counties, our ability and under the jurisdiction of multiple courts are. It'd be nice if, just like when we checked the citation on a case, if it came up with a red flag and said he's in custody somewhere, but it's not quite that straightforward. So I agree. Obviously, in a situation like this, it'd be ideal if a violation wasn't filed. However, at the end of the day, of course, Mr. Yost can reach out to probation and inform them that he's in custody as well, and thus unable to report on time. So, and that reporting is going to be continue to be important. I'll dismiss the charges at this time. However, Mr. Yost, upon your release from the jail, are you available in the office today, Mr. Sanders?
Yes, sir. That's correct.
All right. I want you to report directly to probation, 82 Ionia. Ask for Mr. Sanders. He'll get you set up and discuss with you a time to show up at alternative directions. And I still fully intend for you to check in there and stay there and successfully complete the alternative directions program as we discussed at the time of sentencing.
Can I ask a question, sir?
Yep, go ahead.
When I was sentenced, my lawyer actually brought it up, and because I had a place to stay and that I discussed with James, my recovery coach, and I had IOP set up, that you dismissed the alternative directions, and then you said it was okay to go to my address and do IOP.
Okay, so I decided that AD wasn't necessary.
Yeah, you did decide that. That was on the recommendation, but you actually, my lawyer set it up where I could do IOP and just
Instead.
go. Yeah.
Any thoughts on that, Agent Sanders?
No thoughts at this time, Your Honor.
All right. Well, you still have the place to stay, Mr. Yost?
Yes, sir, I do.
Okay. And I take it where are you going to do the IOP?
I was going to do it. I had the same counselor, Bev Shepard, out of North Kent Guidance. She was my counselor for 5 years, and I'm personally already connected to her. I was going to pick up back there again. I just have to make some phone calls.
Yeah, no, North Kent Guidance is a good source if you can do it. They don't have as many, sessions available as some of the other places do. But you're located. You're going to be living up north side of Kent County.
Yes. Yes.
Okay. All right. Well, I'll give you a shot to do that. I will tell you, Mr. Yost, if it's not working out or Mr. Sanders is feeling like you're not doing your end of the deal, then I'll just send you down to AD and have you do it that way.
Yes, sir.
Or remand you to jail and have you do the sober living unit. We got lots of options here, but my
Understood.
preferred option is always that you get the help you need in the community, because that way, when you're off probation and whatnot, if you need help, well, you know which door to knock on, just like you got that previous relationship with North Kent.
Yes, sir. I used to actually be a recovery coach and worked for North Kent at one point, so I'm familiar with recovery. So I just
Good.
got to get it clicking again.
I understand. Well, and the good news is, once you got some sobriety under your belt, still a high need for recovery coaches and mentor, peer recovery folks out there. So very good. Well, let's go with that plan. Then I'll delete the AD requirement. I'll just have you repeat to report to Agent Sanders today. You have any other warrants or cases that are going to pull you in those other directions that you're aware of, Mr. Yost?
No, I have Ionia County. I am on a personal recognizance bond for a booking fee, but I was told when I was released to Montcalm just to address it when I was let out, I just have to pay $66 to them. So I know that I'm on personal recognizance with them, but I just got to give them the first $66 that I get in my hand. So
I hear you. No,
Yep.
that's a good plan, and that way, I can't believe Ionia is going to have you
I know.
multi-county pickup on a booking fee. I'll have to remind people when they complain about our fees over here that
Right.
we're way less draconian. So, all right, no, that's good. Take care of that $66 obligation, and obviously keep Agent Sanders informed. That's one thing we can do.
Yes, sir.
Is MDOT can talk to other places if you're on probation, you got costs, or particularly those finance warrants out there. If we can get payment plans in place or something like that, that makes your life a lot easier and puts that kind of on a back burner so you can focus on staying sober. So.
Yes, sir.
Very good. All right. Well, good luck to you, Mr. Yost, and thanks for the work on that, Agent Sanders, and also Miss Bauma. Much appreciated.
Thank you.
Yes, sir, Your Honor. Thank you.
Thank you.
Good morning once again, everybody. It is a Super Friday here at TCF Live. I'm happy to have you here with me. A great way to start the weekend, at least in my opinion. Let's go to Ohio. Judge O'Donnell.
Mr. Deeb.
Does that jail time credit include the original case or just this case? Your Honor, I was asking about the jail time credit since this was a refiled case. I believe there's an extra day. And as I thought about it, he was just arrested the one day, and no, 2 days credit, because they arrested him that day and then he found out the next.
So 5 days jail time credit?
He got out at like 6 or 7 o'clock the next day after seeing the credits. So,
Your Honor, we would agree to 5 days jail time credit.
Okay.
thank you, Your Honor. With that, we are ready to proceed to sentencing. Your Honor, we would ask the court to consider judicial release in this case. We know that there's mandatory prison. In his prior OVI in 2014, he received a 2-year plus the mandatory minimum of 3 months. I was going to ask the court for an 18 to 24-month prison sentence that would encompass that 24 days. Obviously, the license suspension and fine are mandatory. But what I was going to ask the court, given the fact that his history is over such an extended period of time, putting him in prison, he'll do his time. He'll be a model inmate. He responds to rules other than the OVI laws very well. He's very likable. I'm sure that people will like him when he's down there. But it's not going to do him any good. He could get his GED while he's down there. He can take programs. But being in prison, those programs aren't nearly as qualified as, say, an IOP or any other programs that would be something that could immerse himself in here. And that would give the court the opportunity to supervise him, have him do programs, but also make him productive, get back to work, get back to his family under that supervision. But he still has to pay the penalty, which would be incarceration. So I propose that to you. If the court were thinking 2 to 2.5 years, or what the court was thinking, extend the prison time so that he would have more time hanging over his head, but consider giving him judicial release after 12 months or so, whatever the court would deem fit. And that way you could tailor a community control sanction package that would rehabilitate him much more sufficiently, or put in certain rules in place that will help him and protect the public rather than just pause everything. Dennis is a very likable guy. Unfortunately, he put himself in this predicament. and he did finally come clean after everything was said and done. But at this point, I think that him rehabilitating himself is the most important thing in Dennis's mind, so that he doesn't put himself back in this jackpot, because he will be getting out. He's taken steps in his life to ensure that his family, the hardship on them is minimized. But he does have the opportunity when he gets out, so that he will be back at work in another good job, being the yard supervisor for the construction company. And with those things being said, even though recidivism is obviously a problem, just letting him languish in prison doesn't really serve much purpose other than just to pause his interaction with society. Thank you, Your Honor. Wait until he dresses you.
These, we had a trial on just 3 charges, right?
Yes, Your Honor. It was count 1, the A1A count, and then count 4 was renumbered to count 2, so that should be the refusal count, and count 5 was renumbered to count 3, that's the misdemeanor count.
Okay.
That's the failure to comply, 6 months or 6 points.
Failure to stop.
Yes, and it carries a mandatory license suspension also.
All right. So 1 and 2 do not merge?
Your Honor, we would elect to proceed on
Okay.
count 2.
All right. So we're proceeding on counts 2 and 3. All right, Mr. Boyd, what do you want to tell me?
Well, Your Honor, I just would like to apologize to everybody involved. I am truly sorry for it. I made a terrible decision that afternoon to have a few drinks after we got done working. I didn't think I was that impaired, but like the prosecutor said, that it does delay your reaction time and those types of things. And it was just a terrible mistake on my part. I'd just like to apologize. After I got out on my last one, a lot's changed for me. I went back to work. I reestablished my credit. We bought a house, and I was doing everything that I was, supposed to be doing. And my wife and I, we have a great relationship. I'm a grandfather now, and I'd just like to have you take that maybe into consideration for the sentencing.
The question is, why have you been doing the same thing over and over again for 30 years?
Sir, when I was younger, I honestly believe I felt entitled to be able to stop and have some drinks after work with the guys on occasion, and I realized it was a huge mistake. That I stopped doing. I honestly did. I don't hang out in bars or anything like that. I just go home, spend time with my family. I don't very rarely hang out with friends anymore. I just hang out with my family, and that's, I would say, the biggest change for me in the last 10, 12 years. And before I was just hanging out with my friends all the time. When I get out of jail, I have a job offering. One of the guys called me that I used to work with and wished me luck in court, and he's offered me a job. He says, when you get out, he says, all we have to do is get you to and from, and you'll have a job when you get out. Don't even worry about work, and so I can get squared away with my fines and restitution and whatnot.
Doing what?
There's a construction company. They want me to work in the yard, organize things like that, get trucks ready to go in the morning. Just a yard manager, more or less. Make sure there's inventory.
Well, when when you testified here at trial, you indicated that you hadn't had anything to drink until you got home, and then you killed a half a bottle or so of Jim Beam.
Yes, sir.
Which was not true, right?
I did drink before I got on my bike. Yes, sir.
So, with regard to that, you told Ms. Knaus that you were doing some additional stumps, and whoever wanted you to do these additional stumps brought a 12-pack, and you had 3 beers while you were
yes, sir.
killing those stumps, right?
Yes, sir.
Okay. But you told Ms. Friend, the drug and alcohol evaluator, that you stopped on the way home and drank.
No, I didn't. I don't remember telling her, sir. I don't remember saying that.
Well, you've got 8 prior OVIs. One's a felony back in 14.
Yes, sir.
And a physical control. These OVIs start in 94. You got a 94, 96, 98, 2000. 01, physical control in 05, 06, 08. And then you got a 6-year break. You get your felony in 14 in Geauga. And now this thing has occurred in 24, so you have a 10-year break. So why did you have these breaks of 6 and 10 years between OVIs?
Well, I had stopped drinking for periods of time. Like I said before, when I started drinking again, I would just go home. I wouldn't. That's all I would do.
Well, hopefully you've gotten to the point where you can quit bullshitting yourself that you're okay to drink as long as you're at home or anywhere else, because obviously you didn't do that.
Yes, sir.
You didn't confine it to that. So, I don't know, this seems like first of all, you got lucky that nothing else happened. Okay. Second of all, this is all so unnecessary.
Yeah. Yes, sir.
All right, anything else you want to say?
I'd just like to apologize again. That's all, Your Honor.
All right, Ms. Tuttle.
Thank you, Your Honor. The state would request that the court impose a mandatory prison term here as is required by law. The mandatory minimum here would be 120 days of prison on count 2. The state would also request a mandatory fine of between $1,350 and $10,500, mandatory drug and alcohol programming, a license suspension of at least 3 years to life, and the defendant to forfeit the motorcycle that was registered to him at the time that this incident occurred. It's clear that the defendant has a long history of committing these offenses, as the court has outlined. We would additionally ask the court to impose a sentence on the misdemeanor offense concurrent to whatever the sentence is on the felony OVI. Thank you.
All right, I've reviewed the pre-sentence report, the drug and alcohol evaluation. I've listened to Mr. Boyd, listened to counsel, considered all the provisions of 29, 29, 11, 12, and 13. And as Ms. Tuttle indicated, this is a mandatory prison case because of the nature of the history here. And so on count 2, I'm going to impose a prison sentence of 54 months with credit for 5 days. Impose a mandatory fine of $1,350. You're to undergo mandatory drug and alcohol treatment. I'm going to suspend your driver's license for 5 years and order the forfeiture of the motor vehicle or the motorcycle. And Count 3, I'm going to impose a jail sentence of 180 days, which by law is concurrent to count 2. Anything further, Ms. Tuttle?
No, Your Honor.
Mr. Deeb?
Do you have to impose a license suspension on the failure to comply? Or not the failure, the leaving the scene?
I have no idea.
I know it carries a mandatory suspension. That's why I was wondering. I think you have to order it.
I believe it's a minimum of 6 months.
Okay, 6 months.
Nothing further, Your Honor.
All right.
All right.
Alrighty, friends. Good morning once again to you. Let's move back up to Michigan. Judge McGinnis.
Good morning, AJ Down, yes, Mr. Boone.
Thank you, sir. Could you state your name?
Kelly Laguna?
Are you still using the same mailing address which I have for you on Alden Drive in Clinton Township?
Yes, Your Honor.
Today is the date and time set for a violation of probation arraignment. Did you review the allegation, single allegation that it has brought your client to court?
Yes, Your Honor. We will waive the reading. I'll send you as for plead not guilty to be entered, but he is prepared actually to plead guilty to today's charge.
Okay, so for purposes of arraignment, I will enter a not guilty plea on your client's behalf as it relates to technical violation number 2. Does sound like you've had a chance to speak to your client about the violation and his right to a hearing, and he wants to proceed today. Sir, do you understand that because you are here facing a second technical violation, there is the potential for jail to be imposed as a sanction? The max jail time that could be imposed would be up to 10 days in Oakland County Jail.
Yes, Your Honor.
And because there is a potential for a jail sanction, this is what entitles you to have a hearing. If you want to have a hearing to contest the allegation that's brought you into court, you have the right to do so, and the city of Troy would be responsible for being able to prove to a preponderance of the evidence standard that you violated probation in this way. That's the burden they would have. Do you understand that?
Yes, Your Honor.
Knowing this, understanding your right to a hearing, and having an opportunity to consult with your attorney, is it your decision today to waive your right to have a hearing?
Yes, Your Honor.
How do you plead to the allegation that you failed to submit to random testing as ordered, which includes failing to appear for testing on 6/26/2026? Do you plead guilty or not guilty?
Guilty, Your Honor.
All right, I will accept your guilty plea. It appears to be freely given. There was a summary report prepared by his PO, Mr. Rappi. Did you review the report with your client?
I did, Your Honor, yes.
What, if anything, would you like to say on your client's behalf for sentencing?
So, Your Honor, Mr. Abuna was, last time he had consuming alcohol was the date of the offense, which was back in August, I believe. He was sentenced in November. He has since completed everything you've asked him to. He's paid all his fines and costs. I think he was sentenced to 9 months probation.
Was.
Correct? Okay. The date of June 26th, so 2 months prior to that, his mom started chemotherapy for her lung cancer. And Mr. Abuna's sister couldn't take their mom that day to chemotherapy. So he was forced to take her that day. It was a very bad day for him. It was very emotional. It's been very tough for him. And no excuses, Judge, he just forgot to call that morning. He did test the day after, and that was negative. Is that correct, Mr. Abuna?
No, he tested on the 29th.
I'm sorry, he told me the next day. I apologize.
That's okay.
He did test this morning as well. He hasn't had any alcohol since the date of the offense. He had no issues with drugs. Everything's been negative. And he is very sorry for that, Judge. He's hoping you could understand that it was just a very emotional day. He was just a wreck that morning. He didn't want to take his mom because he didn't want to see her go through that, but he was forced to, and he just didn't think about it and he didn't call. No excuses, but again, Judge, it has nothing to do with drinking or trying to avoid any kind of testing. So he's asking the court to hopefully forgive him for that and not incarcerate him. I did read the recommendation. It is fair. I'd ask the court not to incarcerate my client. Again, he's had no issues with anything. He's completely sober, no other problems with probation. So I'd ask the court to not incarcerate him. And he's very close to being done. He's been on probation since November, so it's almost, I think, 9 months. So I'm not sure how the judge feels about that. I don't know. I mean, I see what the recommendation is, but considering everything that he's done, hopefully Your Honor doesn't take this to be him trying to avoid testing, because this is not even about drinking or doing drugs or trying to avoid testing.
Did you complete the substance use education weekend?
Yes, Your Honor, everything is completed, all the requirements, all the community service, all the bills are paid, all the requirements, everything is done with, Your Honor.
When did you complete the program? I'm just curious because normally she puts it on here, the date, and I didn't have it.
Yeah, the program was completed maybe 5-6 months ago, early.
Early on.
Yes, Your Honor, early beginning of probation.
What, if anything, would you like to say on your own behalf?
Yes, Your Honor, so I would sincerely like to apologize to you for missing on that day. I have no excuses. Everything is right. I just want to say to you that I'm a hardworking man. I swear I can put my hand on a Bible. I've not touched alcohol, no drugs, nothing like that. I come home and go to work on that day too. With my mom had chemo, so I had to go and take her. That's the reason why I missed that day. But every day I wake up, I call the phone to make sure that I need to test or not. I tested this morning as well, and I've been going for 9 months straight. And I've been this is the second time I try to apply for the early discharge. So I've been trying to take it serious, but it just did not come out in my favor. And I'll keep showing you that I'm not gonna miss no test through the time I have left of probation.
Did you explain to your PO why you missed the test on this day?
Yes, Your Honor.
So she
well, when I went to go see her on that day, when she told me that I missed the test, I was just shocked because I was supposed to be off probation the week after that early discharge. So when I went there, like I was just so much in shock. I couldn't speak. She can say that because the week after that I was supposed to get off probation on early discharge. So when she told me that, I was just like in shock for the couple of minutes that I was in there. I couldn't even speak because I had planned to get off early discharge the week after that. On the 9th, I was supposed to get off.
When you say you were in shock, were you angry with her? Or
No, not with her. No,
okay.
With myself. I was just like, because I was so excited. I thought when I went to go see her that she was going to give me the good news that I was supposed to get off on that day. So when she told me that, just like everything in my head just went to like, whoa. I was just shocked. No, I was not mad at her. I greeted her with the most out of respect you can ask her. I was just shocked at myself. I couldn't even speak. I swear, I was just sitting there with my head down. I was just trying to think of why I did that. All that it was just going through my head. Your Honor.
Okay.
No, sorry.
Well, it's clear that you didn't call on that day for whatever reason, and that's the reason that you didn't probably realize that you had been called to test and that you missed. So unfortunately, you don't get to finish probation early, but I don't know that I am going to extend your probation today either. If I extend your probation, you have to stay on the whole time because once you have a violation, you can't even be considered for early discharge for at least 90 days. If I keep your current discharge date, that means you're just going to stay on for the next 30 days or so as planned, but obviously you've lost an opportunity to be considered for early discharge. And you will continue to test at a pretty high frequency just to ensure that you're appearing every day. You've otherwise done pretty well on probation, but we have had a couple of issues with testing that we've had to address. And the testing is what supports anything that you tell me about remaining free from alcohol and drugs. So it is still important because it's a probationary term that we're verifying that, but I think it's still appropriate to keep your discharge date August 25th. I am going to continue your testing. I see you're paid in full. I do see that you owe your reinstatement fee to Secretary of State and then you get your restrictions lifted. Is there a reason we haven't been able to get back there yet?
I'm sorry, can you repeat that one more time?
So you have some restrictions from the Secretary of State. Do you understand that you have driving restrictions? I hope. Maybe don't answer that question, but
I'll explain to him. He owes some money, Your Honor.
Well, he has to pay his reinstatement fee and then his restrictions will be lifted.
I think he just forgot.
Yeah, I'll pay this one.
I'll make sure he does
I would
that.
make sure that he does that because otherwise he can only be driving under certain restrictions and he could be facing additional criminal penalty if he gets stopped and is driving outside of those restrictions. So I'm going to order that you go to Secretary of State and pay the reinstatement fee so the restrictions are lifted within 7 days. But you're going to do that for your own benefit anyway, whether or not I order it, but that's going to be required for you. No additional costs will be ordered today for the violation, so you're still paid in full here at the court. But you will continue on probation, hopefully with the ability to earn a successful discharge. at the end of August with the continued testing and a return trip to the Secretary of State so that you can get those restrictions lifted, okay?
Sure.
All right, that's it for today.
Your Honor, I'm sorry. Before you cut us loose, I have a request, please.
A travel request, he's got to take it to probation. So that's how they're all handled first.
May I just say something, please?
It's for today.
So, Your Honor, if you could just give me 60 seconds.
Okay.
Prior to this violation, he booked for California for his sister's wedding from today to the 28th. He found a place there he can test. Today, if you want, Monday and Tuesday, they were closed on the weekends. He could try to find the sheriff's department there. He's just going for a wedding and coming back. And
what are the days that he's supposed to travel?
Today at 12:15 is the plane takes off and he comes back the 28th, correct?
Yes, Your Honor, and I told my probation officer for 3 months prior to that, she's been known for the last maybe 4 or 5 months about that specific day. I had told her way before, and I spoke to her about that too. She told me that she doesn't have an issue. I just needed to speak to you about it.
That's fine. Just work out the testing with the probation officer. I don't care if you travel to go to the wedding from today until Tuesday.
Okay, so should he report there right now?
I would, and then they can figure out what would be required for testing. I'm sure we can work something out, even though he has a testing place that's closed on the weekend. I don't have any issue if they resolve it in a way that allows him to go and participate in the wedding and be home on Tuesday. And I'll leave it up to the probation department or the officer to just facilitate what testing would be needed.
Can you go straight there now?
Yes.
Okay, thank you, Judge.
Okay,
Thank you so much.
we'll send over a message so that they know he's coming over.
Thank you very much.
You're welcome.
Should I read that on the?
Good morning once again, everybody. It is TCF Live on a Super Friday. Tim, $2, missing our Barbara. Yeah, I agree. Hopefully she feels better soon. Let's get out of Michigan. Wade Mercer is back behind the bench after a couple days off. Let's check in with him.
Mr. Johnson, good morning. Mr. Johnson, you're accused of what I think are 4 new charges: burglary with assault or battery, depriving use of 911, cruelty towards a child, and false imprisonment. There's also a charge of violation of pretrial release. When I looked at that statute, I don't think that is a criminal charge. The officer lists it as a new charge, but I think that's incorrect. Mr. Mitchell, I meant to text y'all about that and ask you to look at it. But that statute says a pretrial release can be revoked in certain situations. It doesn't create a new crime. I think there is a charge you can file in that situation, but that's if they're on pretrial release. I don't know that that applies to bond. Mr. Mitchell, any thoughts on that?
Not really, Your Honor, regardless of whether or not that is a charge that we go forward on, which I don't expect it to. He was already out on bond in 26309 CF, so we're going to request that his bond be revoked anyway.
Thank you. Mr. McDaniel, anything?
Nothing, Your Honor.
Oh, Mr. Johnson, I'm going to file on the violation of pretrial release. Mr. Mitchell.
Your Honor, I'm sorry, I forgot to mention this, but before we started first appearances this morning, I did get a call from Lieutenant Griffith over at the Mariana Police Department. He was aware that in at least 26309 CF, he has a no contact provision with the alleged victim, and that's the same the alleged victim in these new charges. Lieutenant Griffith told me that the second he got into jail, and even this morning, he was already contacting the victim via the telephone. So we'll leave it up to the court to determine about whatever they want to do with his telephone privileges. I just wanted to bring it to the court's attention and let you know what Lieutenant Griffith told me.
Okay. So, Mr. Johnson, on the violation of pretrial release, the statute they've charged you under is not a criminal statute. It does not create a new crime. I'm not saying there isn't a statute that fits. There very well may be, but the one that the officer cited in his complaint doesn't even give a criminal offense. It's not a crime at all. It's just saying that your pretrial release can be revoked under certain circumstances. So you don't have to post a bond on that case. That's not a criminal charge. The other ones, the burglary with assault or battery, your bond's going to be $100,000. The other 3, your bond's going to be $10,000 each. Your total bond today is $130,000. Do not try to post it because I'm revoking your bond in 26309 CF because there's certainly evidence that you violated a condition of your bond by getting arrested and by having contact with someone I ordered you not to. So don't try to post bond because even if you do, you won't be released. Mr. Johnson, that condition, no contact with the alleged victim still applies now. And some explain what that means. You cannot talk to her by phone at all. I'm going to ask the jail to double check your calling and make sure you have no contact with her at all. If you contact her, or if you contact her through a third person, what's going to happen is Mr. Mitchell's going to then come back and say, Judge, we want you to take his telephone privileges away, and that's what I'm going to do, most likely. You can have no contact with her. You can't put a friend on there and call the friend and have that friend do a three-way call with this person. If that gets back to me, that's a violation of the conditions of your bond. It's a violation of your telephone rights, and you will lose all telephone rights except your right to call your attorney. So don't put yourself in that situation. I want you to be able to talk to your mom and your other family members. But if you get caught talking to her, then you're not going to be able to talk to anybody except your attorney. So be aware of that. As far as your court date goes, I want to ask Mr. McGinnis to notify your attorney in the other case of your bond revocation ruling, and that they'll notify them, and they'll be aware that you're in jail with no bond now. They'll come see you at the jail. And the new charges, your court date should be August the 4th at 8:30 will be your court date on the new charges. Let me see if your mom has any questions. Ma'am, do you have any questions? Ma'am, I want him to be able to hear your question. So if you don't mind, come on up here so he can hear your question, okay?
Okay, the young lady's stuff is at his house. So is it okay for her to go over there and?
Yeah, he's not going to be there. He's going to be in jail.
Because she had went to his house.
Well, not in this case, not what the complaint says. This wasn't at his house. This was at her new place, according to what this complaint says. That's what the complaint says.
On Washington Street?
Yes. Yeah, that's what well, the complaint says that she told law enforcement she had moved there and that he did not live there at 2843 Washington Street. Let me make sure I'm reading this right.
The lease
And just a second. Well, just a second. Let's make sure I'm right, because it's certainly possible I'm wrong. Pretty sure I'm not. And all I know is what she told law enforcement.
Yeah, we don't disagree, Your Honor. That's what it says, but it's his rental house. I mean, he's in there.
She went there.
Leslie stated she had moved into the residence approximately 1 month prior, and Johnson did not live at the residence, nor did he have permission to enter. All that means is that's what she told law enforcement. Okay. So if she's got stuff there, she has a right to go and get it if she's on the lease or if she's got permission to be there. If she doesn't, she needs to contact somebody who does have authority to let her in that property. Now, if she was living there, you just said it was in his name.
Mary Ann Davis / Samad Johnson.
Okay. If she was living there, she's got the right to go there and the right to continue to live there until she's lawfully removed. So you know the situation better than I do. But if she was living there, she's got to be lawfully removed by a lawful process. That's an eviction. It can be some other type of court order. But that's what's got to happen if she was living there. Any other questions?
Samad, I don't know anything about her being there, so I don't know.
He doesn't need to talk about the charges. He needs to talk to an attorney in private.
Okay.
Okay. Either way, he has a condition of no contact, so he's not going anywhere. His bond's revoked. It's done.
Okay.
Let's say the new charge was dismissed today. He's still not going anywhere because there's evidence he had contact with someone I told him to have no contact with.
Correct.
Okay.
Does this stand for her too? No,
No, ma'am. No, you can't put a condition no contact on alleged victim because they haven't done anything wrong, at least not legally. So if there's an injunction or something, that could keep her away from him, but a court order against him is not necessarily a court order against her. Now, if let's say she calls and she entices him over there, potentially there's charges she could be charged with if she encourages someone to violate the law, potentially.
Okay.
Okay. So, Mr. Johnson, do you have any questions?
No, sir.
All right, sir. I wish you the best. Thank you for coming, ma'am.
You're welcome.
Judge,
Pamela
do you need a proposed order?
So, folks, I have to pause for just a second here because if you'll notice behind Mr. Mitchell, he's got what looks like his pantry open, and there is food product on the racks there on the back of the door. Now, I think this is significant because it disproves a common belief that so many of us have, and that's that lawyers feed off of the misery of others. And we now know, obviously, that at least in part, that is not true. They do not just feed off of the misery of others. Okie dokie, back to court.
I'm sorry, Mr. Mitchell.
Do you need a proposed order?
I do need a proposed order on that order revoking bond, please.
Okay, I'll have it today.
Thank you. Pamela Turner. Turner, good morning. Ms. Turner, you're here because you're accused of one count of driving under the influence, ma'am. There is probable cause for the charge in the complaint. Ms. Turner, I've also looked at your criminal history, and I'm appointing the public defender's office to represent you. Please listen to Mr. McDaniel, your attorney, ma'am.
Your Honor, I spoke to Ms. Turner. You would just ask the court to consider some kind of, release option, maybe conditional release if the court's inclined.
All right, Mr. Mitchell, anything?
No, Your Honor.
Ms. Turner, are you employed, ma'am? Or I think I saw in here where you're disabled.
I'm disabled.
Where do you live at?
I live in Chipley.
The only thing on your criminal history is a DUI from years ago in Alabama. There's no disposition on here. That's 2013. So it's about 13 years ago. Have you been charged with a crime since then?
No, sir.
You can pick between a bond and a conditional release then, ma'am. If you want to post the bond I set for DUI typically is $2,500 cash or surety. If you want to accept the conditional release, ma'am, I'm going to offer you a conditional release with your criminal history. You're going to have a condition this is not an alcohol related DUI. You're going to have a condition not to drive under the influence of any prescription that may cause drowsiness. That's what you're accused of doing, is taking a prescription that you shouldn't drive with and driving while you're on that prescription. So you'll have a condition that you can drive, but if you're caught driving and you're drowsy and you've on some medication and there's evidence of that the medication says don't drive, then ma'am, that can revoke your conditions of your bond or your conditional release. Every conditional release has a condition of no alcohol. So that's a standard condition. Do you have any questions about that choice, ma'am?
No, sir. I don't drink. I'm not an alcoholic.
You don't have no problem complying then.
Okay.
No, sir. Any other questions? And do you want to choose the bond or the conditional release?
Conditional release.
I'm going to grant you the conditional release, Ms. Turner. I know that Mr. McDaniel has already explained what that is to you, ma'am. What's going to happen, Ms. Turner, is that you'll be brought to the courthouse in Mariana. You'll meet with a conditional release officer, ma'am. They'll go over the release with you. Before you leave the jail, they'll let you get dressed in your regular clothes. They will also let you use the phone for transportation if you wish. So if you do call friends or family, ma'am, you can tell them you can be picked up at the courthouse in Mariana in probably 30 to 45 minutes from now. Ms. Turner, do you have any questions?
No, sir.
All right, ma'am. Thank you. We'll see you in a little while. Ms. Turner, the jail's also, or somebody will give you notice, probably the jail will give you notice for your court date. When will that be? August 31st at 9 a.m. will be your court date, and the jail will give you that notice in just a second, okay?
Yes, sir.
Jeremiah Phillips. Mr. Phillips, good morning. You're here because you've got a couple of issues going on in Jackson County. You're accused of one count of failure to register as a sex offender. Gaston County has a warrant for you, a hold for the exact same charge over there, different circumstances, but the same charge. They have you over there and over here. So, Mr. Phillips, have also taken a look at your criminal history, and I believe I'm the judge that signed the warrant in Jackson County. So there is probable cause. I found that before I signed the warrant. Mr. Phillips, I think you're entitled to a bond in Jackson County. Let me listen to the attorneys and I'll set that bond and we'll go from there. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell?
Nothing for the state, Your Honor.
Thank you. Mr. Phillips, your bond's going to be $10,000 in Jackson County. The Gaston County warrant has no bond on it right now. What that means is when you get there, you may or you may not get a bond. The reason your bond is $10,000 is because you got the same charge in two different counties from two different alleged incidents. That's why your bond is that amount. But you have the right to use the phone in a few minutes, sir, to try to post the bond. And if you post it, you'll be released. Your court date will be August the 4th at 8:30. The jail staff will give you that notice in writing in just a few minutes. Do you have any questions?
No, sir.
All right, sir. I wish you the best. And Melissa Harrison. Ms. Harrison, good morning. Ms. Harrison, you're here, ma'am, in case 24-486 CF. Judge Garcia, the circuit judge, has revoked your medical furlough that appears to be based upon a new arrest in Washington County, a new charge in Washington County. See, your medical furlough is revoked. You've got no bond, ma'am. I'll ask Mr. McDaniel to notify your attorney here that you're in jail with no bond, and you'll be seen in an upcoming docket before Judge Garcia. Ms. Harrison, do you have any questions?
Judge, just to give you some background on this case now, because I had to do a lot of research on it this morning. I was confused. So she's on probation. She's put out of this. She went to bars to bed back in 2025. While she was waiting, I guess she was having medical issues. So they released her on the, that for medical furlough. So she's pled. She has no attorney. I'm kind of not sure why no one's violated the probation, but she's on state probation for this. So, but she doesn't have an attorney. I'm trying to let Judge Garcia know about it. I don't know what, I'm doing with it but yeah, she's pled. She's on probation. She just never has. I told her for right now what she's here doing. She'll be here waiting until she gets her bed available. But obviously with those pending charges in Washington, I'd be seems like highly unlikely she's going to go to rehab.
Did she had an attorney when she pled, correct?
Correct.
Wade Owens.
Wade Owens.
Okay.
And I'll let Wade Owens know.
Yeah, it is a confusing case. Mr. McDaniels will notify Mr. Owens of the situation, ma'am. Whether you have to go back in front of Judge Garcia or not, it appears to me that you probably do to clear up this revocation medical release, but it may be such that if there's no violation of probation filed, which the probation officer is probably watching the first appearances this morning, if the if the charge in Washington County happened after you were on probation, it should result in a violation of probation affidavit being filed. If it was an arrest for an older warrant, an older incident that allegedly happened before you were on probation, it can't be used to violate your probation. So we'll ask probation to take a look at that, see the date of the new offense allegedly occurred, and go from there. Have you resolved the new offense in Washington County, or is it still pending?
Still pending, Your Honor.
Okay. All right. So Mr. Owens should see you at the jail over the course of the next several days, ma'am. Okay. Thank you. Mr. McDaniel, anything else from the public defender's office this morning?
No, Your Honor.
Mr. Mitchell from the state?
Nothing from the state, Your Honor.
Corporal, anything from the jail?
No, Your Honor.
All right. So, ladies and gentlemen, that concludes first appearances this morning. Just a second, everyone. I'm going to tell you something about the conference I went to, and we'll do that off of YouTube. So, first appearance court is adjourned. It's 8.
Well, that's no fun. I wanted to hear about the conference that he went to. At least now we know why he was gone, I guess. Good morning once again, everybody. Coming up on hour 2 now of TCF Live. Let's go back up to Michigan, Judge Elmore.
Ready?
Yep.
We are on the record this morning now for the 28th Circuit Court here in Webster County. And we're taking up 5 files. Each case is entitled People of the State of Michigan versus Daniel Joseph Bungie. The file numbers are 26-14255 FH, 14256 FH, 1257 FH, 14258 FH, and 14306 FH. Appearances from counsel, please.
Nick Carnes on behalf of the people.
Julian Sauer on behalf of Mr. Bungie.
Thank you.
We're calling the fourth, the final case. Should the other counsel be present?
I've got 5 files.
I've got 4.
So yes, there's another one. Yep. Mr. Carnes, you're already here all, right?
I'm here on all 5.
All right. There we go. And appearance, please.
Connor Shantz on behalf of Mr. Bungie, excuse my right.
Thank you. All right, so we're here today for some final pretrial conferences in these files, and the parties have presented to the court a couple of pretrial agreements.
Your Honor, may I approach?
You may. Good, thanks. All right, I'm going to go over the agreements here that I see written before me. Mr. Bungie, is that what you're expecting to do, is enter some please?
Yes.
Please raise your right hand to the best you can. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes, sir.
You may lower your hand. Now, on the date of any of these alleged offenses, Mr. Bungie, were you on probation or parole anywhere?
No.
Were you on bond pending any felony charges anywhere?
No.
Thank you. All right, so I'm going to go over the terms of this agreement, or these two agreements. Now, actually, there's 5 agreements, 2, but they're resolving in 5 cases. If at any moment in time you have any questions, just let me know. All right. In file 26-14255FH, you are currently charged with a single count of possession of the controlled substance methamphetamine. That is a felony punishable by up to 10 years and or up to $15,000. Plus, there are 2 potential sentencing enhancements that either one could be applied at the time of sentencing. The first is a second or subsequent drug offender enhancement. That could increase the potential punishment from up to 10 years to up to 20 years, and from up to $15,000 up to $25,000. Or in the alternative, you can be sentenced as a 4th habitual felony offender. That could increase that potential punishment from up to 10 years to up to life. However, I'm told that based upon a plea that we'll be talking about in a moment in the file ending in 5-6, that entire file will be dismissed. In file 14256, you are currently charged there with delivery of the controlled substance methamphetamine. That's a felony punishable by up to 20 years and or up to $25,000. And once again, there are those 2 potential sentencing enhancements. The second or subsequent drug enhancement could increase that potential punishment from up to 20 to up to 40 years, and from up to $25,000 up to $50,000. Or as a 4th habitual felony offender, that maximum punishment could be increased up to life. However, I'm told today that you're going to plead guilty to that count of delivery of methamphetamine, and in exchange for that, there'll be other benefits taken on these other files. At least specifically here, the enhancements will be dismissed, so you'd only be pleading guilty to a delivery as a felony punishable by up to 20 years and or $25,000. Do you understand?
Yes, sir.
Now, in this particular file, there's also an agreement that you would pay an amount of restitution of $380 to the Travelers Narcotics team. And there's also an agreement as to sentencing. Now, this agreement is a kilobrew agreement. A kilobrew agreement is an agreement that you make or a defendant makes with the prosecution. I don't know if I'm going to go along with it. But if I don't, then you would have the right to withdraw your plea, and we'd come back to this stage of proceedings with all the files. Now, that kilobrew agreement is that I would sentence you to no more than 78 months. Now, I perceive that that means that's the minimum amount.
Yes, sir.
All right. The reason why I needed the prosecutor to state that is so I can turn to you and have you agree. When the court sets a sentence for a felony, it looks at the Michigan sentencing guidelines. Those guidelines are not mandatory for the court to follow, but they are, courts are required to consider them. Now, those guidelines help courts establish what should be a reasonable and proportionate sentence, and also help eliminate some disparity across the state. So when that minimum number is over a year, then I have to add on to the end the maximum punishment. So really what this means is a minimum of no more than 78 months, it could be less, with a maximum term of up to 20 years. Does that make sense?
Yes, Your Honor.
All right. So for instance, if I went less than 60 or 78 months and I gave you 5 years, it'd be 5 to 20. Got it?
Yes.
All right, thank you. Now, turning to file 14257, there you are charged with another count. In fact, it's basically identical to the last file. Again, delivery of methamphetamine, a felony punishable by up to 20 years and or $25,000, plus 2 potential sentencing enhancements of a second or subsequent that could double those punishments within the discretion of the court, or as a 4th habitual felony offender that could increase that potential maximum from 20 up to life. However, based upon the plea that you're going to be entering in file 14256, which we just covered, that entire file will be dismissed. Do you understand?
Yes.
Now, somebody step on a mouse? No? All right, never mind. All right, counts in file 14258FH. In this file, you are also charged, just as you were in the last 2 files, with a single count of delivery of methamphetamine, which is a felony punishable by up to 20 years and or up to $25,000, plus there are those 2 potential sentencing enhancements. That within the discretion of the court, as a second or subsequent drug offender, that punishment could be increased from up to 20 to up to 40 years, and from up to $25,000 up to $50,000. Or in the alternative, if sentenced as a 4th habitual felony offender, that maximum period could be anywhere up to life. However, that entire file will be dismissed based upon the plea that I expect that you're going to place on the record for 14256. Now, in this last file, it is number 14306, and in this file, you are charged with single count of larceny in an amount of $1,000 or more, but less than $20,000. That's a felony punishable by up to 5 years and or up to $10,000 or 3 times the value of the property stolen, whichever is greater. Now, there's a 4th habitual felony offender that could allow the court to increase that potential punishment within its discretion from up to 5 years up to life. However, count 1 and the habitual enhancement will be dismissed if you enter a plea of guilty to an added count 2. That added count 2 would be a larceny of something of value of at least $200 or more, but less than $1,000. That would be a misdemeanor punishable by up to a year and up to $1,000. And there's no enhancements for misdemeanors. Now, it also says here that you, for restitution, you are acknowledging that the potential restitution could be more than that $200 to $1,000. You understand?
Yes.
And then that you apparently be agreeing to pay that. Does that make sense? I don't, or is there going to be a restitution hearing?
There's going to be a restitution hearing. Restitution is contested, but
okay,
he just needs to agree.
All right, so you could be liable for that, but it looks like if it comes down to it and there's a disagreement, then you're going to have the right to have a hearing to have the prosecutor prove how much restitution is owed. Is that what you understood? All right, good enough. Thank you. All right, now I have here 2 written agreements. I'm going to go over the first one. This first one is listed as being for file 14256, but it makes note here about what's happening with the other drug-related files, not the theft file, the one that's 306, but the other ones. Now on page 2, it appears to have a signature, and it looks like it's yours. Is that your signature?
Yes, Your Honor.
Now, before you placed your signature on this, was your counsel available, Ms. Sadler, sorry? Did she talk to you about the file, the evidence, the police reports, your options, going to trial, things like that?
Yes, she's been awesome.
All right, good. So you're satisfied with their counsel up to this time?
Very
great. Thank you. Also, looking at file 14306, there's also another written agreement here, and I'm holding it up, and it sure looks like your signature on page 2. Yep. Is that your signature there?
Yes, Your Honor.
All right, and before placing your signature on this, just a minute, Mr. Chandler, get the, no. Still learning.
Shots.
Shots, I don't know why I said, oh, wait. His first name's Connor.
Yes.
I don't know why I had that. All right, anyway. Did Mr. Shots do the same thing, make himself available, talk to you about the evidence, give you all your options, things like that?
Yes, Your Honor.
Are you satisfied at this time with his advice?
Yes.
Great. Now, in each of these files, I've got what's called an advice of rights form. And I've got one here. A second. Oh, here they are. There's one for 14256 and one for 14306, and I'm holding them up. Looks like it is. Is that your signature on the bottom of each of these two documents?
Yes.
Now, before placing your signature on these two documents, did you read through the information above?
Yes, Your Honor.
Did you understand what was written?
Yes.
And you understand that if you enter pleas of guilty, as we discussed, you're not going to have trials. Is that right?
Yes.
And you understand that by placing your signature on here and by entering pleas, if I accept those pleas, you are forever waiving these rights as to file 14306 and 14256. Is that correct?
Yes.
All right. You also will be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me today on the record. Other than the terms of the pretrial agreements, which we've gone over, has anyone made any other promises, threats, or inducements to force or compel you to plead guilty?
No.
Are you entering the plea of your own free choice?
Yes.
Moment. Does that apply to both of these two files?
Yes, Your Honor.
We have talked a little bit this morning already about potential sentencing. Now, I talked to you about how there's an agreement to 78 months or no more than that for the end of the minimum. Has anyone made any promises to you or suggested to you exactly what I would do at sentencing?
No.
All right. And have your attorneys talked to you about those sentencing guidelines, explained how they work at all?
Yes, Your Honor.
All right, good. So I need to highlight once again for you that those are not mandatory for the court to follow. The court must use them and consider them, but it is within the discretion of the court to issue the sentences. Do you understand?
Yes.
All right, 1 second. I'm just cleaning up some more paperwork. Do you have any questions before I ask for your pleas? No. All right. We're going to turn first to 14256. As to the single count of possession, delivery of the controlled substance methamphetamine. How do you plead?
Guilty.
Before the court can accept that plea, I'm going to have to ask you some questions to have you explain to me what it is that you did that makes you guilty of that offense. Turning your attention in this file to February 11th of this year in the city of Cadillac, here in Wexford County. What happened?
I call from a friend that I do drugs with. They were looking to get meth. I knew where to get it. So they came. I had to take me where I went. I went in, procured methamphetamine, and then sold it to them.
Did you know that that substance was methamphetamine?
Yes, I did.
And you knew that you were delivering it or providing it to, whether for money or not, to another person. Is that correct?
Yes, I did.
And in that particular instance, it sounds like there must have been a transfer of money. Is that right?
Yes.
All right. And when you did this, you did it of your own free will. Nobody was forcing you or anything else like that. Is that fair?
Yes.
How much of it was there that you delivered? Do you remember?
5 grams.
Okay. All right. And so when you delivered, when you picked it up from the first source and then took it to the recipient, could you see it? Was it in a baggie or?
Yeah, it was in a bag. So the person picked me up and gave me the money first.
Okay.
They had to take me to the place where I got it. I went inside, they waited out in a bag. I gave them the money, I came out, and then I put it in the cup over the vehicle.
All right. All right. And that all happened here somewhere in the city limits?
Yes.
All right. Thank you. Mr. Carnes, do you believe the defense provided a factual basis to support the plea in file 14256?
Yes, sir.
Are you aware of any other promises, threats, or inducements that we have not yet discussed?
Your Honor, I can't remember if the restitution of TNT was covered. I apologize.
I did cover it when I talked about the plea. So that was there some kind of transfer of $380 for you to go inside and purchase that?
It was, yeah, they're done with all 3 cases, all 3 times adding up to that much. There was.
Oh, I understand that. All right, so.
And the restitution for all 3 cases.
All right, great, thank you.
$150 at that time.
All right, that makes a lot of sense to me. All right, thank you. Mr. Carnes, are you, do you believe the court's compliance with the court rule 6.302?
Yes, Your Honor.
Sadler, do you agree with all 3 of those answers?
Yes, I do.
Thank you. The court agrees and finds the defendant's plea in that file is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the required elements of proof. Therefore, the defendant is found guilty of count 1. Now we're going to turn to file 14306. We've already gone over the pretrial agreement, your rights, and so forth. So we're just going to jump to the plea. As to the added count of larceny, of where there's a value of at least $200 or more, but less than $1,000, how do you plead?
Guilty.
Before the court can accept that plea, I'm going to ask you some other questions. Turn your attention to February 6th, 2026, out in Harry Township on the north end, here in Wexford County. What happened?
Went to Walmart with my little sister shopping. I went to grab a cart to put the baby in. There was a wallet in the front part of the cart. I opened the wallet up. There was a lot of money. I took it out. And then I just tossed the wallet back.
You did you know whose wallet it was?
No, I didn't even look at the ID. At the time I didn't have my own house. It was snowing and
So you didn't know who it was, so therefore you didn't have permission to take the money out of the wallet, is that right?
Yes.
And how much money was in there? Hold on, let me ask you this one. Was there at least $200 that you took out of that wallet?
Yes.
And it was actual U.S. currency, is that correct?
Yes.
Mr. Carnes, do you believe the defendant provided a factual basis to support the plea?
Yes, Your Honor.
Are you aware of any other promises, threats, or inducements?
No, Your Honor.
Do you believe the court's in compliance with Mr. Paul 6.302?
Yes, Your Honor.
All right, Mr. Shops, do you agree?
Yes, Your Honor.
Thank you. The court agrees and finds the defendant's plea today has been made freely, willingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the required elements of proof for the added count 2. Therefore, he is found guilty of that added count 2. All the remaining charges and enhancements will be dismissed at the time of sentencing. Mr. Bungie, these 2 files will be set for sentencing. Now, actually, all 5 come back because they don't get dismissed until we get to sentencing. Remember, you have that killer rule agreement. Therefore, if for some reason I don't go along with it and I were to sentence you to more, then you'd have the right to withdraw your plea. That's why they're not all dismissed until they come back for sentencing. So it may largely be a formality, but I need to make sure you understand that. Anytime someone's convicted of a felony in a state court in Michigan, an agent from the Michigan Department of Corrections, also known as the Probation and Parole Office, must prepare a pre-sentence investigation report. Because today you had 5 files and one was resolved felony conviction and one was not, you're only going to have a PSI on the new charge, but they're still going to talk, the felony, but they'll still talk about and make a recommendation, but there's no guidelines for him as to the misdemeanor. Now, this report will describe the offense, the pretrial agreement, any information you make or provide while it's being prepared, information about your prior criminal history, employment history, education history, how you've done on bond, probation, or parole, where that's appropriate. It will include that score into the guidelines, which again is temporary, and we don't know exactly what they're going to be, but they give us their best shot at it. And again, they're not mandatory. There will also be a recommendation in the report, and that recommendation is strictly that, a recommendation, as it is I that will make the determination on the sentence. Do you understand that? Yes. Now, there are 3 steps that involve you in preparation of this report. First of all, I'm going to let you know we should be back in about 4, or it could be 6 weeks for sentencing. We do sentencings in this courtroom generally every Monday morning. Between now and then, step 1, you're going to get a packet, and that's been handed right now by the clerk over to the bailiff, and he'll give that to you when you leave, and you're going to complete that once you get back to the jail. Also, you're going to be subject to an interview with an agent from that office, and you have the right to have your counsel or counsels present at the time of that interview. And third, once this report is prepared, one or maybe even both of your attorneys will come by and talk to you about it. Each side has the right to come back to this court on sentencing day and raise objections, amendments, seek corrections on information that they think needs to be added or thinks need to be corrected, such as the score into the guidelines, things like that. Do you understand?
Yes, sir.
All right, good enough. Do you have any questions, Mr. Bungie, about what we've done today?
No.
And am I saying your name correctly? I'm sorry if I'm not.
Yeah, it's Bungie.
All right, thank you very much. All right. Mr. Carnes, the court's going to revoke bond, remand the defendant into custody. Anything further on behalf of the people?
There.
And Ms. Sadler, anything else on your 4 files?
Thank you. I think that everything the court has said is accurate. I did want to place one last thing on the record.
Sure.
Okay. When we were scoring the guidelines, we came up with it being either 78-month minimum or 72-month minimum. That's where the kilogram came from. So it's entirely possible that we're actually in a 72-month grid. That would depend obviously on the OV factors. And I just wanted to bring that to the court's attention that we chose the higher of the 2 regardless.
That's all right.
To make sure it was in the guideline range.
No problem. I try to keep it within the guideline range, to reduce at least an appellate issue to one of them. So, and I think we avoided any other appellate issues so far. So, all right, Mr. Shantz, anything further on your file?
Nothing further.
Thank you. All right, Mr. Bungie, thank you very much for resolving these files today. We'll see you in about 4, maybe 6 weeks. Thank you very much. We're adjourned.
Hour 2 of TCF Live on this Super Friday. Good morning to all of you. Lindsay gifts 10 memberships. Thank you so much, Lindsay. We very much appreciate that. Let's go to Texas. Judge Stevens.
That's all I know about that.
There's one case here called. It is 25 CR 1839 Vernon Bronson Williams III. You're here with John West, your attorney, and the state's attorney. You're charged with unlawful possession of a firearm by a felon. Is this habitual felon status?
Don't know, Judge, and don't have the case.
Okay.
It wasn't on
Was
my docket.
convicted 2012.
Get into it.
Convicted in 2013. This use of firearm in a crime of violence, then illegal possession of heroin.
Excuse me.
And then
That was loud.
after those convictions were final, he was finally convicted in 2018. Introducing contraband into the correctional institution. Also in 2018, he was convicted of a separate offense of introducing contraband. So what we have here, though, is an habitual felon status. And where are we?
At this point, we were still working on it. I thought we had it set for down the road, and then it popped up on the docket today, so I'm not sure.
Oh, I'm sure. We don't do something today, we go to trial, period, in a ball game, and which is 25 minimum to life. But I mean, you can't wait around for you to decide. You were indicted 7-8 months ago. You've had more than enough time to decide, but you're not eligible for probation.
A jury, yes.
By a jury. This is what this is, sir. This was a decision on, let's see.
Yeah.
What direction you're going to change?
It'll be divided up between one of the three of us,
No.
4 of us.
Is that?
I don't know. This
When were we here last?
I don't remember the exact date, but
These cases we said. 7.
sometime a few weeks ago. Yeah.
Because he had a bad drug test somewhere along the line.
Right. As you revoked his bond, he made a new bond, and then so he's now back on.
Okay.
Yeah. So
You have a drug patch?
yeah. Yes.
What are we going to do?
At this point, we'll set it for the trial docket.
Then that's what we want to do. That's what we want to do, because we just go. That's what you want to do. We're going to focus on this one, and it'll be set, and no deal. That's it. We go forward. That's 25 to life. And note it, this is a chance to resolve it, and there are no deals. We go to trial. Thank you. All right. Denise Woods, are you here?
Yes, we are.
What are you going to do? Is this it's a motion to revoke probation? Yes, that's what this is?
Yes, Judge.
Y'all ready?
Station, Judge.
Okay. Where did Mr. Rennick say he was? 30 seconds out?
No, that was John. I haven't gotten in touch with him.
That was it. Aaron Simpson was to be pleaded out, I think.
Yes.
All right. Well, I will keep an eye. We'll come back when he racks up the next contestant. In the meantime, let's go back to Florida. Brantley Clark has hearings this morning.
Hey, we have, hush. We got Bay County Criminal Division B, motion docket, sorted docket, whatever it is. My name is Brantley Clark, Circuit Judge, who's currently assigned to this division. Who do we have? Who is that?
Yes, sir.
Who's got Mr. Cotton?
Sir?
Are you ready? Yes. What are we doing, Mr. Cotton?
We have, Dr. Schuler has been appointed to evaluate him, but I think she is out of town at the moment.
Okay.
But we finally have.
I need to say something to you, Your Honor. I want to say something too.
Make it quick.
Okay, well, since you put it like that, I'm under the impression that, I'm not being taken seriously of in a sense. So I feel like
let me promise you, I'm taking you seriously, but I'm going to set you for a hearing on August the 21st at 9 o'clock. We'll see you then, Mr. Cotton. That'll conclude the hearing.
Okay, well, I mean,
yes, sir, the hearing's over with. We'll talk to you later. Oh, there you go. And I'll take a bunch of these today. Y'all give them to me.
Can y'all hear us at the jail?
I'm ready to go back. Well, I ain't got one. I don't know why I ain't got one. And they keep playing this motherfucking game. And she already told me.
Mr. Carter, Mr. Turner, let's go ahead and do Miss Carter. She here? We're here today on a status review. This is State of Florida versus Sonic Carter, 25 CF 114. Carter is going through restoration process, but she's not doing very well. The last
update that I saw.
Miss Carter, you're gonna have to start complying with my order. We'll have to either put you back in jail to let you do it, or take you to send you to the Florida State Hospital.
Understand? You gotta go to your appointments. He's gonna put you back in jail or back at the hospital, okay?
You understand?
Not just the medicine, you gotta see the counselors too. She's been updating her medicine, but you haven't been seeing the counselor. That's the problem, Judge.
You've got, look at me, Mr.
Look at
Carter.
him.
I'm not kidding. You've got to go through this restoration process. The doctor says you can be restored. You're gonna have to do the counseling. You understand? Yeah. Okay. I'm gonna set this for September 25th at 9 o'clock, and I expect to have a report that you're cooperating. You understand? Yes. Okay, good luck. We have Mr. Hall up. Mr. Carter, you here? Hey, Mr. Hall, tell him to close that door where I can hear.
They say close the door? Okay.
Thank you. Mr. Hall, I brought you back to court today just to place something on the record. I had neglected to do it yesterday. You were sentenced to a term of life, but I failed to place on the record that there's a 3-year minimum mandatory that comes with that sentence. And I'm not sure I have to, but I'm gonna go ahead and announce it on the record today. There's a 3-year minimum mandatory. Okay.
And Your Honor, since he's here, we need to know if he wants me to represent him on his other case.
Mr. Hall, okay.
Or if he wants to represent himself.
You represent yourself. You want to represent yourself on the manslaughter?
Yes, sir.
Okay. All right. Well, I think I've already gone through the colloquy on that, and we haven't come back in September on that. Is that correct?
Yes.
All right. You still have your notice. Mr. McCarthy is going to file your notice of appeal. So that'll conclude today's hearing. Good luck.
Thank you.
Mr. Hatcher? This is Mr. Owens. Case number 24 CF 3343. Mr. Owens was sentenced yesterday to a term of imprisonment, 25 years on the robbery with a firearm, 25 years on the aggravated battery with a firearm. They were both 25-year minimum mandatory, and I had failed to place that on the record yesterday. So that's what I'm doing today.
Your Honor, I also want to put on the record that
I'm not putting anything else on the record today. I'm just making, if there's a motion or something, you can file a motion to correct the sentence, but that's not what we're here today. I'm just announcing the 25-year minimum mandatory on both counts to run consecutive. That's all I'm doing today. So if there's any other motions, they'll have to be filed.
yes, sir, I will.
All right. All right, that'll conclude your hearing, sir.
Hey, Mr. Karen, I want to appeal that. I want to appeal. I just want to let everyone know for the record, I want to appeal this.
I don't blame you. I would too.
Yeah, I mean, that ain't what you gave me, ain't right.
All right, that'll conclude the hearing. All right, Mr. Meredith, Mr. Colvin.
Bitch, yeah, man, the bitch ass cracker talking about some this, that, and the fuck.
Judge, this is Scott Colvin, case 26-1295. Dr. Schuler, I believe the report was filed yesterday.
Let me read it real quick.
upstairs for the baby. I'm not so bad. I'm sorry, it was bad right now.
I've just reviewed Dr. Schuler's report. Mr. Meredith, Mr. Colvin asking for another assessment.
No, sir.
Mr. Pereira, has the state had an opportunity to review that mental competency examination?
Yes, sir.
Evaluation? Are you satisfied or are you asking for another extra?
We're not.
And any objections to me accepting that report and evidence and finding Mr. Colvin competent to proceed at this time?
No, sir.
That's what I'm prepared to do.
All right. Your Honor, we have 2 PIAs.
All right.
Doesn't need to be fingerprinted for either
You're
one.
going to, you'll get me an order on the competency, correct?
Yes, sir. Miss Copeland's listening in and she'll get that.
What does he have to be fingerprinted on?
He doesn't.
No, he does not.
Oh, that's what I thought. All right, Mr. Colvin, good luck to you, sir.
I mean, Miss Nolan. Your Honor, Ms. Nolan had been evaluated by a doctor and we could not understand what the recommendation was. So Dr. Schuler was appointed to follow up.
Okay.
Dr. Schuler tried to see her the last couple of weeks and Ms. Nolan is expressing an interest in her right to remain silent. So.
But then, Ms. Nolan, based on that, you're going to stay in jail
That's fine.
for a long, long time because I can't.
Well, I'm not gonna let you violate my right to remain silent. I'm gonna keep my right to, that test has nothing to do with being competent. It's asking personal questions and questions about my
We'll set
case.
this for September 25th at 9 o'clock. We'll see you then, ma'am.
Yes, sir. And I will come to the jail to talk with you. Okay.
I represent myself and I'm gonna remain silent. That's all.
You're not doing it right now.
I don't care. I trust in God, not man.
Amen, sister. Amen. Me too. All right, Mr. Hatcher, you ready? Okay. Mr. Meredith?
Mr. Martin? No, not Mr. Robertson, Mr. Martin.
Oh, I'm sorry.
Now, this is Tashad Martin. He's back for sentencing. You accepted his plea.
right. You know, I don't think we can do this anymore. This is the last one. Sentence someone and set them off for sentence. Complete somebody. Yeah. All right. Mr. Martin, you're before the court today for your sentencing. You've done what you said you did. You come back and you have not picked up any charges. I've already accepted your plea. At this time, you'll be adjudicated guilty of felony battery, sentenced to 24 months in the Department of Corrections, given credit for 5 days served. Your assessed fines and cost of $1,028. Those include discretionary cost of $2 of local law enforcement education, a $65 assessment for additional court cost, a $150 discretionary public defender fee, and a $200 discretionary fine. The fines and costs are reduced to a civil judgment. There's no restitution applicable in the case. Department of Highway Safety and Motor Vehicles may apply additional penalties. If you're required to give a DNA sample, you must submit one, forfeit any seized item, no contact with any victims. Sir, you have 30 days to file your notice of appeal. If you wish to appeal this judgment sentence, you'd like to have an attorney to represent you and you can't afford one. One may be appointed to represent you at no charge. Good luck to you, sir. You just step over, be fingerprinted.
You're, I believe you fingerprinted
That's right,
him.
fingerprint. All right, so
so
you're
that he
just going to
can be-
custody today. Mr. Raymond?
Morning, Your Honor.
Good morning.
May it please the court, I have one case before the court, Your Honor, State versus Eliza Chamberlain, 24-1366. Put on today's docket for status check. We have received the discovery from the Gulf County investigation. And the process of getting those depositions scheduled. Talked with Mr. Pereira in an effort to try to narrow the witnesses down there because a lot of that doesn't have any relevance to what we're doing here, but some of it does. And there's also going to be some out of town travel as well for depositions, but we're on top of it and got things moving forward.
We'll set it maybe for the September 24th, September, maybe October. What's our October pretrial out of custody? October the 13th.
That'd be fine,
At
Judge.
9 o'clock.
That's all I have, Your Honor, unless Madam Clerk tells me different.
Have a good weekend.
Thank you, sir. Good to see you.
Good to see you too.
Thank you, ladies.
Somebody, you got something? Mr. McCarthy? Anybody? Mr. McCarthy?
Good morning, Your Honor.
Good morning.
Eric Smitherman. Your Honor, this is Eric Smitherman. He has 3 cases, 26-905, 26-380, and 26-44. He has 2 motions today. The first motion is to reinstate his bond. His bond was revoked because he got new charges.
Got a job and a place to live and everything else. I still got a job and a place to live out there and everything is still inside it. My
All
family.
right, you want to call any witnesses? or
Yes,
make
sir.
calls?
I'm going to call Mr. Smitherman.
Yes, ma'am.
All right, you may inquire.
Okay, please state your name for the record.
Eric Smitherman.
And where do you live, Mr. Smitherman?
I live off Sherman Avenue on 17th Street. I got my own place out there still. Actually, my family's been keeping it up in Bay
Okay,
County.
and do you work?
Yes, sir. Yes, ma'am.
Okay,
Yes,
where
I
do you work?
I work for a pool company and through Jake. It's like a L&M pool. We do
Okay.
cleaning.
Okay, and if you are released, you have transportation back and forth from court?
Yes, ma'am.
Okay. And do you have family here?
Yes, ma'am. I've been here all my life.
Okay, and who's your family?
I got Tanya, I got Sean, my brother, I got my brother William. I got pretty much all my family lived here. Been here for all my life. I'm from here.
Okay, that's all. No more questions.
All right. Yeah, any questions?
No, yeah.
All right. Any other witnesses?
No, Your Honor.
They'd have the witnesses.
No.
Exposition?
Position is that the revocation of bond is reasonable due to new charges.
Ms. McCord?
Your Honor, we're just asking to let him go back and work on it so we can, so it's easier for us to meet.
I'm gonna deny the motion to reinstate the bond based on the new charges.
Yes, sir.
that were filed. I believe the information has already been filed. Mr. McCarthy represents him on those.
Yes, sir.
That
And
brings
then
up the next motion.
the next motion is to be able to have contact with Ms. Russ.
Yes, ma'am.
Ms. Russ.
State's position.
I'll leave it up to your discretion.
Is she in jail?
No, sir. She already pled and she's actually, Ms. Russ, are you
Yeah,
here?
yeah, she's already
She's in the
pled.
audience.
She's already pled. I'll allow peaceful contact.
Thank you. Okay, that's all.
All right, we need another court date for Mr. Smith.
Restatement. They denied it. Okay.
He's already on the 20th. Okay, we'll leave him on that 20th.
Okay, thank you.
Thank you.
Yes, sir.
DeJuan Troop?
Who'd you call?
DeJuan Troop?
I spoke to Ms. McCarthy about this earlier this week. The motion got filed a little bit late and I didn't have time to properly serve officers. And both of those officers wouldn't be available for today, so I'm asking for continuance on this.
No objection.
Come back next month.
We'll set it for August 21st at 9 o'clock.
Thank you.
Okay, thank you, Your Honor.
Yes, ma'am. Somebody, you ready?
Good morning. How are you?
I'm well.
Good. Your Honor, this morning I have Tyler Leon, and that was a motion for an order to show cause that was in 243823.
All right, Mr. Ferrer?
I don't think that my office attempted to serve him. We attempted to contact him and told him to be here today. That was about the expression that I had. I don't think that we received a response from him. We attempted to contact him this week and early last week.
And Your Honor, the first deposition for this that he was served on was in March of 2025. I think we've tried to deposition him 5 or 6 times at this point. He's not here. The last time I had a deposition set for him, the state attorney's office, I think it was Morgan McAfee that day, since Jackson is out, attempted to call him. Their office attempted to call him. He's been emailed at least twice that day. So at this point, it's a 2024 case. The arresting officer is not participating and hasn't been participating since the very beginning. We've asked that this case be dismissed.
What's the state's position?
I could try to get him served and back here or with something. Kind of, you know, I don't know the full ins and outs of the case. That's the only.
Is there a motion? Is there an order to show cause?
I'm sorry, Your Honor.
It is a motion for.
It is a motion for orders. Yes, Your Honor. But
he wasn't, you don't know if he was served with it.
He was not, well, he wasn't served for this hearing today.
But now, he was served by notice by email. Is that good service for a deposition?
Yes. Or an officer.
What about the alleged victims in the case?
Sorry, Your Honor.
What about the?
I believe that I'd have to look. That was before my time.
Just cause I'm not going to dismiss the case just cause the arresting officer is not participating, but I could be convinced to exclude him.
Well, and Your Honor, part of it has been, number one, that the arresting officer isn't participating to this point. The second part of it is that the alleged victim, to my understanding, from the beginning, I think there was a civil side to this case and that got taken care of. And that since that happened, he hasn't really been participating. So there's different parties who just are not participating in this case that are prohibiting my client from moving forward in this case at all, because we're waiting on the state's witnesses.
What makes this an aggravated battery anyway?
I'm sorry, Your Honor.
What makes this an aggravated battery?
This basically was a road rage incident where the alleged victim hit my client with his car, and then my client, I guess, allegedly, there was some brushing against the car. Like I said, this has been a civil matter that's already been taken care of. And as far as I'm aware, since I've been on this case, which has been since at least October of this past year, not Mr. Ferreira, but one of the assistant state attorneys has been trying to get in touch with the victim and hasn't been able to.
This is Mr. White's case?
Yes.
I'm not inclined. I don't know that there's not a motion to dismiss the case at this time. And I don't know that I can dismiss a case for.
Yeah, well, I'd like to get to the bottom of this.
Yeah.
I've been on this case a week.
Sure.
I need to.
Nothing against JP.
Seems to be a lot of.
Hearing for August 21st. Allow you the chance to serve me with the motion of order to show cause, and then it can be done away with between then. I certainly would appreciate it.
Absolutely.
All right.
Thank you.
Anything else?
Yes, Your Honor. I also had Chandler Vincent with you this morning, but I think an order came through for that.
Oh, y'all seen that order? So
I did.
We need to, y'all got some work you need to do, both sides. You want to set up maybe for August 21st or September 25th?
I think it was August 21st. Your Honor.
August 21st is when I set it for? Okay, we'll see you then.
And then, Your Honor, I do have a trial management this afternoon.
Yeah, call that case.
It's Nicholas Sanderling, and that's in 243701 and 243555 with Mr. Sullivan.
All right, are we set for trial?
Mr. Brand taking case for UMS or
Okay. This one we continue from June. Okay. I'm gonna try October. Ms. Humber?
Yes, Your Honor, I think that's fine. And that same day, Your Honor, before you, we have, O'Shea Kadori and John Gonzal.
Okay.
And I believe Mr. Sullivan had kind of run into the same thing with those as well.
Okay.
That are set for that day.
All right, so October is that 5th, Madam Clerk? And September 25th at 1:30 for trial management.
What was the September date, Your Honor?
25th.
25th, okay. Thank you.
Thank you.
Alrighty, friends, it's starting to calm down there just a little bit, I guess is a good way to put it. Let's move along then, try something different. Let's go to San Jacinto, Texas. This is Justice of the Peace, Judge Blanchette.
She's going to enter a plea of no contest to count 1, domestic violence strangulation, a 3rd-degree felony, maximum penalty 5 years in prison. Adjudication would be withheld. She'd have 36 months of supervision with court costs and fines of $1,028. 100 hours of community service work at the rate of 8 hours a month. $20 a month for cost of supervision. Provide a DNA sample, forfeit any item seized. No contact with the victim, and successful completion of the batterer's intervention program at her own expense. And that is the extent of the agreement, Your Honor. Okay.
You don't need anything.
Okay, hold up a minute. I'm not exactly sure what went wrong here, but I tried to switch to San Jacinto and it doesn't look like a switch. So let's try again.
Name, sir.
There we go.
Your name?
Nathan Johnson.
Mr. Johnson, I'm Harris Blanchette. I'm the Justice of Peace here in San Jacinto County.
Yes, sir.
You are charged by warrant 26S 7048CR out of Precinct 3 of San Jacinto County with the offense of evading arrest or detention and misdemeanor class A. Do you understand that charge?
No, sir.
You don't understand what it means to evade arrest or detention?
Oh, yes, sir. I understand that.
I'm just asking if you know what it means. I'm not asking
Yes,
you if you did it. All right. Well, you have the right to hire an attorney to represent you. You have the right to have the attorney with you while you're being questioned by peace officers or attorneys that represent the state. You
Yes,
have
sir.
the right to remain silent. You're not required to make a statement, and any statement you make can be used in court against you. And you have the right to stop any interview or question at any time. Do you understand those rights?
Yes, sir.
And do you need a court-appointed attorney, or are you going to get your own?
Yes, sir.
Do what?
Yes, sir. I need one.
You do need the court-appointed attorney. All right, no problem. Let me fill out this form so we can get that straight. The
Yes, sir.
jail staff will assist you in completing that paperwork. All right. Are you a citizen of the United States?
Yes, sir.
Are you currently out on bond for any of the charges anywhere else in the state of Texas?
No, sir.
Okay. The judge that issued your warrant has set your bond at $5,000. Do you have any questions?
Yes, sir.
What's the question?
They've already served me with this same warrant a month ago, and they didn't even arraign me on it and now they're trying to serve it to me again.
I don't know anything about that. You'll have to ask, I guess, the deputy who arrested you why he's arrested you again.
It was two different officers brought the warrant paper down there and served it to me in the tank, and then they never arraigned me on it last time. Now they served it to me. Now they're arraigning me on it. I don't understand how they could do that.
I'm not sure. I don't have all those details, so I can't answer that question.
All right.
You get the court-appointed attorney, he can answer that question for you.
Okay, yes, sir.
Are there any other questions I can answer for you?
No, sir.
All right, thank you.
All right. Thank you, Judge.
Thank you, sir.
Alrighty, friends, that is San Jacinto and Judge Harris Red Blanchette. Something new, something different. Now let's go back to the things we know, Judge Elmore.
Let's go ahead and start with appearances, beginning with the prosecutor's office, please. Thank you.
Joanna Carey for the people.
Good morning, Mayor. Please, this Honorable Court, Kareem Johnson, for behalf of Mr. Nicholson.
Thank you. Mr. Nicholson joins us this morning from the Westford County Jail. Mr. Nicholson, are you able to see and hear the court this morning, sir?
Yes, Your Honor.
All right, thank you very much. Give me just a moment to catch up with my notes. All right, this case is before the court this morning for a final pre-trial conference. The defendant is currently pending some charges. Looks like they involve alleged deliveries of methamphetamine with some enhancements. And I think we were last on the record back in June for an alleged, a bench warrant and then an arraignment. And the defendant resolved it by admitting to violating his bond conditions. So we're here today for a final pretrial conference, with this case being on the court's current docket for trial. Mr. Johnson, what's going on with the file today?
Your Honor, I'm asking the court for an adjournment, and I know that the court's order requires this to be written. Since we last appeared before the court, I've had 2 trials. I currently have a homicide jury trial deliberating. They just started deliberating yesterday. I did receive an email from Ms. Carey about resolving this matter. I have not been able to respond to that email. I take full responsibility for nothing being accomplished since we were last here in court. I do believe the judge that I'm in front of did email or leave a message with the court yesterday about why this trial that I'm in now got extended from 1 week to 2 weeks. So I am humbly asking the court for an adjournment.
All right, thank you. And I understand. And I think we got a message. Nicole?
I got a message from somebody yesterday that I was in trial.
So my staff has confirmed now that that there was a message received from the court where your trial has been. All right, thank you very much. Mr. Johnson, I don't recall if we have appearances, or did the prosecutor not get one?
I didn't get the appearance or the substitution of counsel.
All right.
But I did.
But you got a copy from the file this morning?
I received a copy of just the substitution from the court this week.
All right. So, all right, Mr. Johnson, I want to check here. Do you have a discovery yet, or at least the police report and the charges? I know you replaced Mr. Harrison from the public defender's office.
I have all the discovery from Mr. Harris. There were some text messages that were referred to in the police report. I would like to get the actual phone text message from the phone, but that is something that I have not communicated with Ms. Carey about yet.
All right, thank you very much. Let's take a look here also. So we're looking at this request to adjourn. The allegations here, the alleged offense date is July 24th of last year, 2025. So it's about, it would be an alleged anniversary today. Anyways, the case was filed on January 8th of this year. There was an arrest date of January 14th of this year. The defendant posted bond 6 months ago on January 24th. There was a probation revocation by the Judge Wiggins, and Judge Ransom somehow issued a PR bond. Anyways, I don't know anything more about that, but we know we had some probation or bond violations when this court issued a bench warrant back on May 13th. The reason why I cover all that is, number one, it's the defense requesting this adjournment. Number two, I find that there is good cause to grant the adjournment. Number three, while we're at the 180-day mark, give or take a couple days, We're actually 10 days over it, at least from the arrest date. Defendant had not been in jail for that entire period and had been in some status where we didn't know where he was. So that means that the speedy trial right clock is not yet pressuring this court to move it ahead of time. I'm sorry, to force it to go to trial. Ms. Carey, I should have asked your response to the motion to adjourn.
I don't have any objection. I would ask that Mr. Johnson contact me so we can discuss the case.
In my experience, and I don't think anybody will disagree, Mr. Johnson does not tend to drag his feet. So I'm quite confident he's been busy. And of course, with the message we had from the other court, that the trial that has eaten up a lot of his time in the last couple of weeks has gone a little bit longer than anticipated. Therefore, the court will grant the motion and will have the matter set for another final pretrial and a new court date. Mr. Johnson, I have no doubt that you will, but just remind you, make sure you get out and contact Ms. Carey. If there's anything else you need, like recordings, think about those things. Typically, I would anticipate some kind of body recording device if there was any confidential informants here or whatever like that, but I know you know what to do. Anything else, Mr. Johnson?
No, sir. Thank you.
All right. So, Mr. Nicholson, hopefully I didn't have you speak, but hopefully I said everything well enough for you so you understood what and why, what's going on and why. All right?
I understand.
All right, good enough. Thank you very much. If you have any questions, it's probably not appropriate to ask me, but of course, make sure you speak with Mr. Johnson. All right, folks, we are adjourned. Thank you. Thank you.
Alrighty, friends, now entering hour 3 of TCF Live as the morning flies on. Let's stay in Michigan, go to the Lansing area, Judge Flores.
That's Mr. Case. All right, so we're on the record in 26-01890. That's People of the State of Michigan versus Jonathan Case. Appearances for the record, Mr. Decker.
Andrew Decker on behalf of the people, practicing pursuant to MCR 8.120 under direct supervision of Prosecuting Attorney John DeWayne.
All right, that's granted, and you only have to make that motion one time today. Ms. Robinson, appearance for the record.
Erin Robinson, Assistant Public Defender for Mr. Case, who's appearing by Polycom.
And sir, you are Jonathan Case, is that correct?
Yes.
And you can hear me all right, Mr. Case?
Yes.
All right, thank you. This is the time set for a probable cause conference. Mr. Decker, how are we proceeding?
So my understanding that the defendant would like to plead to an amended count 1 of use of cocaine.
Okay. And that would be under PAC code. So 1 year and or I can't remember, $1,000.
Sounds right.
Yeah. All right, so we'll wait for the PAC code, but that PAC code is just to ensure that we got the right, that we're running the right information. That's use of cocaine, 1 year and or $1,000. A plea to the amended count 1. Is that a fair statement, Ms. Robinson?
It is.
All right. May I inquire of your client of their advice of rights, Ms. Robinson?
You may.
All right, Mr. Case, you understand you have the following rights, and I'll walk you through those rights. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by Attorney Erin Robinson. She would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir?
Yes, I do.
You have the right to have the court order any witnesses appear in your defense to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what we've stated on the record or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial. Since you won't be having a trial today, you'll be pleading to the use of cocaine instead. Is it still your wish today to plead guilty to the use of cocaine?
Yes, it is.
Okay, and that's a 1-year misdemeanor. What's the PAC code for that?
1-year misdemeanor and or $2,000.
2,000.
The PAC code for that is 333.74042A.
Perfect. Thank you. I'm going to have you raise your right hand as best you can, Mr. Case. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right. I'm going to bring your attention back to July 11th, 2026 at 801 Stanley Street in the city of Lansing. Did you at that time, were you on Stanley Street in the city of Lansing on July 11th, 2026?
I was.
And did you have the opportunity to use cocaine on that date?
Yes.
And you knew it was cocaine when you used it?
Yes.
And you did not have a pharmaceutical prescription for that, for the use of cocaine, is that correct?
Sure.
All right. Anything else for the record in docket? Anything towards a factual basis for confirmation, Mr. Decker?
People are satisfied, Your Honor.
Ms. Robinson?
Defense is satisfied.
All right. I find the factual basis to be knowing, voluntarily, and accurately made. And we'll refer to probation. So we'll get a probation report. So probation will be down to see you to do a PSI, and then we'll set it for sentencing, and we'll see what options are available to us at sentencing. Sentencing is set for September 4th at 8:30. So probation will be down to see you, Mr. Case, and then we'll see what options are available to us on September 4th at 8:30. Anything else for the record, and we'll make sure that the PSI is done concerning this matter. Anything else to be done on 2601-890, Mr. Decker?
Nothing from the people, Your Honor.
Ms. Robinson?
No, Your Honor, thank you.
All right. All right, Mr. Case, probation will be down to see you. You should be all set. Thank you for your appearance today.
All right, thank you.
And then Ms. Rossi, did you want to go on the AG case? Mr. Ianni, how are you?
I'm doing fine, Your Honor.
Did you want to go on Mr. Shear? All right. And is Mr. Shears on Zoom?
I'm guessing.
Yes.
What was, you said PSI, is there something else? All right, so we're on the record in docket 26000598. That is people of the state of Michigan versus Zachary Shearer. Appearances for the record, Mr. Ianni.
Good morning, Your Honor. Robert Ianni, Special Assistant AG on behalf of you.
Ms. Rothstein.
Good morning, Your Honor. Vita Rothstein from the Ingham County Public Defender's Office, appearing on behalf of Mr. Shear, who is appearing via Zoom.
And sir, you are Zachary Michael Shearer, is that correct?
Yes, sir.
And you can hear me all right, Mr. Shearer?
Yes, sir.
All right, thank you. This is the time set for a probable cause conference. Mr. Ianni, how are we proceeding?
We're prepared to move forward. We've made a plea offer, Your Honor, and at this point, my understanding is the defendant's considering.
All right, and we're just leaving it on then?
We're leaving it on. It was my first opportunity to give Mr. Shear, present the offer to him today. So he would like some time to think it over, and I can respect that. I think people should take 24 to 48 hours to consider things.
All right. So we'll leave on for the previously scheduled prelim for July 31st at 8:30, and then you can let Mr. Ianni know if you need any witnesses or what we're doing for next week. Okay.
Sounds like a plan.
Yes.
All right. Anything else for the record in 26-00598? We've left it on for July 31st at 8:30. Anything else, Mr. Ianni? Ms. Rothstein?
No, Your Honor.
All right, Mr. Shear, we'll see you live in person next week on July 31st at 8:30. So Friday, it'll be Friday at 8:30. All right, sir?
Yes, thank you.
All right. Please keep in contact with your attorney, Ms. Rothstein. We're all set. Thank you for your appearance today. Thank you, ma'am. Thank you, Mr. Ianni.
I'm sorry. What was the charge or?
Use of cocaine on case.
Yeah.
Ms. Robinson, do you have DOC?
Yep. We're ready on that.
Before we lose him.
Yep.
Let's call Mr. Pallion, who's in DOC.
Good morning.
Good morning. All right, so we're on the record in docket 26-01759. That is people of the city of Lansing versus Patrick Pallion. Appearances for the record, Mr. Decker.
Andrew Decker on behalf of the people.
Ms. Robinson.
Erin Robinson, Assistant Public Defender for Mr. Pallion, who's appearing via Polycom from MDOC.
And sir, you are Patrick Pallion, is that correct?
That's right, Your Honor.
And you can hear me all right, Mr. Pallion?
Yes, sir.
All right, thank you. This is the time set for a probable cause conference. Mr. Decker, how are we proceeding?
It's my understanding we'll be leaving this set for a preliminary examination, Your Honor.
All right, and is that a fair statement, Ms. Robinson?
It is, Your Honor. Thank you.
All right, and I'm going to make sure that we have writ out Mr. Pallion for that date.
Yes, we do.
Okay, so we'll set it for preliminary examination for the previously set date of July 31st at 9 o'clock. All right, so we've left on for July 31st at 9 o'clock. That'll be live in person on the 6th floor of City Hall of Lansing, and we've done a writ for that preliminary examination. Anything else for the record in 26-01759, Mr. Decker?
Nothing further, Your Honor.
Ms. Robinson.
No, Your Honor. Thank you.
All right, Mr. Pallion, we'll see you next week, next Friday at this time. It'll be 9 o'clock. We'll see you then. Thank you, sir.
Thank you, Your Honor.
Alrighty, friends, hour 3 of TCF Live. Let's go back and check in again with Brantley Clark.
This is with Mr. Sullivan, Your Honor. This is Ronald Hires, case 26-0199. We're here for a motion to reinstate his bond. I'm not sure if the state has an objection or not to it. I believe everything is contained within the motion, but if you'd like to hear testimony from Mr. Hires, he's available.
All right. Based on the motion that he reported the next day and was arrested the next day at the courthouse, I will reinstate his bond at this time.
And then we need a new court date for him, Your Honor.
All right, we'll set it. You want to set it for August or September?
Let's go to September.
September 15th at 1:30.
Okay, so when you get out, make sure you come back on that date. You'll need to sign for your next court date. Ms. Bennett, did you have one?
Good morning, Judge.
Good morning.
I'm here for Ontario Pool, case number 261036. We're here on a motion to reduce bond. And
They call you first witness.
okay, in this case, I want to just briefly bring to your honest attention. Initially, when Mr. Poole was arrested, he was charged with 6 crimes, and the state filed on 4 of them. So there is a bond for the 2 remaining ones, 12,500, that should be administratively lowered because they're no longer charged. And that would be the carrying a concealed unlicensed firearm and possession of paraphernalia. Those have not been charged. So that would be the beginning of our argument on that.
I agree with that. So that brings the bond down to $57,500. Is that right?
That's correct.
Okay.
And then I'm calling Mr. Poole for brief.
Sir, if you'll raise your right hand.
Yes,
Can you give us your name, please?
Ontario Pool,
And Mr. Poole, where do you normally reside?
Atlanta, Georgia.
And if your bond would be lowered and you can make bond, would you be able to work or supported by family and friends?
Yes,
And how can you ensure the court that you would show up for your court hearings or stay in contact with me?
reporting to you.
And you've been in contact, your family has been in more contact anyone could ask for. And so there's definitely that. As far as the allegations go, while there is a firearm involved, the allegations are that Mr. Poole was stopped while driving during twilight hours, not having a headlight on. The officers claimed they detected the smell of marijuana, and the car was searched. Mr. Poole was not involved in any of the spring break brouhahas.
That's it, Mr. Is that all the questions you're going to ask him?
Yes.
Sub, do you have any questions? What's the state's position?
Your Honor, the defendant doesn't have any ties in the community. He's got a prior robbery conviction, and he's looking at mandatory minimum prison times in this case. Given all of that, the bonds are reasonable.
Ms. Bennett, I'll allow you to respond to that and continue your argument.
Yes, so in this case, like I said, there were 2 people in the car. The firearm was not found on him. He was not involved in any violent anything or illegal anything that we usually have during those times. So I think he is in, and like I said, his family has been in continuous contact. So I think he would be a good candidate for a lower bond. The family has not been able to make the bond as is.
What I'm going to do is I'm going to lower the $50,000 bond on the possession of a firearm by convicted felon to $25,000. Drive my license suspended, revoked, I'm going to reduce it to $1,000. Marijuana, I'll reduce it to $1,000, and giving a false name to $1,000. So that's $28,000.
Yes, sir.
We'll leave him on a in custody docket. Sir, if you do bond out, you need to make sure your address is current with the clerk's office, and you stay in touch with Ms. Bennett. We'll set him for September 24th at 9 o'clock for a hearing. If you bond out, that hearing will change. You need to stay in touch with Ms. Bennett, okay?
Yes.
Thank you, sir. That's all I have this morning. Maybe
Have a good day.
excuse me. I'll be in touch.
Patrick, you ready?
Yes, sir.
Good morning, Judge. I have 2 matters on your docket. The first one is State of Florida versus Tristan Stickney. So it's a trial management case, Your Honor.
Okay.
we're still in talks, but I know we're set for the trial docket. I believe we're going to leave it there for the time being.
All right, we'll leave it on the trial docket for August 3rd, and then, of course, you can resolve it that morning if you need to.
Yes, Judge.
Or place on another earlier docket next week for somebody else.
Your Honor, the next case I have in state of Florida is Brandon Han. This is a case we filed a motion for immunity under Standing Ground statute, Judge.
Okay.
And there was an issue with the face of the motion. I have refiled an amended one. I believe Mr. Sullivan and I talked about, he had not received it yet. He and I talked this morning. So I would like to set it for your next motion hearing document.
August 21st at 9 o'clock.
Yes, Judge. Thank you. That concludes my business, Judge.
Have a good day.
Thank you.
Your Honor, this is James Warren. He is, there's a new order to evaluate him for intellectual disability.
All right, the order's been, has that been, the appointment been set up?
I don't know the sister may know. Is there an appointment with the doctor set up yet?
Okay, very good. No, I believe if you tell me. We'll set for September 25th at 9 o'clock for a competency hearing. All right, sir, if you'll sign a notice and just stay in touch with your sister, okay?
Yes, sir.
Keep doing what you're doing. And Judge, on Zoom is Jeremy Turner. I believe he's signed on with his phone, but I know it's him.
Yes, sir, I'm here.
Since we were last here, I think he has started the shots, but he has an in-person appointment with the doctor on Monday. Is that correct, Mr. Turner?
Yes, sir.
Is there anything else you can update the court about?
No, I mean, I have nothing. I haven't seen him yet, so I have nothing to update.
All right. We need to get back on the trial docket.
Sure.
When we set it for December, that'll give a chance to whatever shots, and I know the pretty busy between now and then anyway, so.
And any update I get, I'll update Mr. Meredith.
I appreciate it. Yeah, and before Mr. Sullivan can say it, this is the oldest case I think he's got, so I know he wants to get it tried. And I do this oldest case, the oldest case he's got, the oldest case I got.
And Mr. Turner, is still okay to share with Mr. Sullivan those updates? Is that right?
Mm-hmm. Yeah.
Turner, okay. All right. So we're going to set this for December.
Sorry, but it was cutting out on me. Sorry.
Okay. December 7th at 8:30 for trial. We'll set it for the October trial management, October 22nd at 23rd at 1:30.
October and December. Thank you, sir.
Yes, sir. Good luck.
Thank you.
Good luck Monday. Mr.
All right, friends, let's head back up to Michigan, Judge Elmore one more time, and then probably Dungeon Court after that.
The next file is People of the State of Michigan versus Laura Webster. The file number here is 26-14193FH. Appearances from counsel, please.
Lisa Dawes for the people.
I'm Jeff Harrison. I'm here on behalf of Laura Webster. She's joining me at the table.
Thank you. You may be seated. We are here today on this file for a final pretrial conference. As it stands, this is the last case currently set for the next trial date of August 11th. I'm just saying why we're here. And now now that I've got it on the record, why we are here. We had a request back on May 22nd to adjourn, and that was granted. I think that may have been the first final pretrial conference back on May 22nd with a jury trial date of June 9th. We did take another look. Have we had any other adjournments? No. Then we're set for today with the trial of August 11th. We also look further into the file. This case has an alleged offense date of January 9th, on which also there was a filing of the complaint and an arrest. The defendant was released on a bond posted back on January 14th. So this case is getting kind of hairy. Let me take another look at something else. Yeah, we actually had a final pretrial conference also back on April 10th. So we've had 2 final pretrial conference adjournments. And the case is getting a bit old. What are we doing today?
Well, Your Honor, people asked to adjourn. We do not have the lab results yet. We have some lab results, but not the ones that are relevant to this case. Additionally, Ms. Webster was just arraigned on a new possession of methamphetamine offense this morning in district court. That's for an offense that happened prior to this case.
All right.
And I believe that we may be able to reach a global resolution while we wait for the lab results. So we ask the court to indulge us again and grant an adjournment, because at this point we would not be able to proceed to trial without those lab results.
And to build upon that commentary, I have a great deal of confidence that we will be able to resolve both matters forthwith. Some of the necessary stuff, if you will, is just procedural, such as a bind over, etc.
Well, let's take a look at this. One could say certainly that the parties both need to confirm before they make any resolution that the substance at issue here was or was not methamphetamine, or they need to be able to decide whether or not to go to court. Now, that is up to the parties. I assume there was some kind of field test done.
There was, Your Honor.
So obviously nobody needs to and it could, if he or she knew what the substance was, doesn't need to wait for the report. The only reason I'm going to say this is because of judicial economy to get the other file up. That I'm not going to adjourn again. Okay, I'm going to make the prosecutor go to trial, and I will sign a subpoena that has the director of the forensics lab be the witness or be a witness to come here and explain to the court why they cannot do their job in a timely fashion. Now, I'm sure it's not the fault of the person who's doing the testing, but it's somewhere up that chain that leads all the way down to Lansing from Grayling, who can or cannot do their job in a timely fashion. Otherwise, I'll just dismiss the case. So that's the problem that the executive branch deals with when they are not funding it's not your office, not the local prosecutor's office, or even the public defenders. But if the state of Michigan isn't going to put in the time and effort and the money to get their testing done, not my fault. It's not the defendant's fault. It's not Ms. Dahl's or Mr. Harrison's fault.
No, we appreciate the timing of the court's there.
I would much rather call and have subpoenaed the one who runs the facilities to come down. And by the way, I sat next to the director of MSP yesterday at a meeting. I should have, if I would have known, I would have turned over and said, how come y'all can't do your job? So anyways, and I'm not trying to be mean, but it's highlighting the importance here.
I
Yeah,
think it's a reasonable time frame for us to get what we need to get done. Secondarily to that, Judge, I would like some special dispensation on this matter because the plea that we're anticipating entering would be the product of a plea agreement. And I know it's the court's standard rule that no such plea agreements will be recognized after the final pretrial.
but we don't have a final pretrial yet because we're adjourning today.
Okay.
Yep, so, right, if we're not doing a trial, I'm not adjourning the trial, I'm just adjourning the whole final pretrial.
I got you.
I understand.
I misunderstood your original pronouncement.
Okay,
So.
no worries. Maybe I was sounding too stern today. I think last week I was asked if I was in a good mood before anybody entered the plea. Anyways, all right, the court will grant the adjournment. This adjournment is based upon judicial economy to get the other case up here. That'll probably mean that'll be pushed out a week, or I'm sorry, a month, at least a month. That should give you plenty of time to do whatever you need to down at district court. And if that case is bound over, fine. If not, we'll deal with this next time. But this thing has got some hair on it.
Yeah.
And if next time we don't have a lab report, Mr. Dahl, I will just issue the show cause. All right. Thank you very much.
Thank you, Your Honor.
We're adjourned.
Alrighty, friends. Time for the last half hour of TCF Live on a Super Friday. We've had to do abbreviated versions of this the last couple of weeks, so I'm proud to give you a little more this week. If you're new to the channel, you're about to experience the best worst court in existence. The blood red carpeting, the sandstone walls behind the judge that, if you look closely, you'll see little bits of blood seeping out. The cries of the undead from the background, the printer that never stops running, the Soviet Cold War era lighting hanging above both desks. Prosecutor as old as the crypt keeper, a judge who was best friends with Pontius Pilate. He's been around so long. People enter this place in fear, and well they should. They say Appalachian justice is best served in a cold, dank basement. Therefore, my friends, I give you Dungeon Court.
9 o'clock, September 4th.
Kimber.
David Moore, Judith Napier, Veronica Reynolds, Otis Sexton, Denise Sexton, Cody Smith.
Moore is 25,135. Any service done. And is there anybody here from RRS? Usually it's Jeremy, but okay, he is here.
I completed with RRS.
Yeah,
Okay.
I completed. Certificate should be here.
Okay, yeah, it is in the file. So we're just paying off fines now. You did make a payment a few days ago.
Yes, sir.
Pretty substantial payment, so. It's for Fridays for your hearings.
Fridays.
Fridays?
Yes, sir.
September the 11th. Get it paid off, you don't come in.
All righty. Thank you, Your
September
Honor.
11th, 9 o'clock. Judith Napier, 22, 27, 47. She's at Southern Hope. Standard community service. Is compliant. Can you pay anything on your fines?
No, not today. I'm waiting on disability right now.
Okay.
But I'm on week 3 in college next week. Next week will be week 4. I should get my school money the week after that. So whenever I get my school money, I can put some down.
Okay. I'm going to put your next hearing for September the 8th. Now that's a little unusual because it's going to be a Tuesday, not a Monday. September the 7th is Labor Day. So we'll have court on Tuesday rather than Monday of that week. So September the 8th, 9 o'clock is your next hearing.
Thank you, Your Honor.
You're welcome. Veronica Reynolds.
Your Honor, if I may, she ran community service in this school also.
Okay. Got a report from GFR. Screens are good. And is compliant, so good job.
I'm doing 2 days a week community service, so I'll have more of that done before I come back.
Okay.
That is correct, Your Honor.
All right, very good. Good job. You want to keep it on Fridays, or does it matter?
It don't matter.
Okay, and I'm going to put you on the 8th also. That's going to be a Tuesday, September the 8th. 9 o'clock is your next hearing.
Okay, thank you.
You're welcome. Keep it up. Good job. Otis Sexton. Otis Sexton is cases 24-539, 24-770, 25-397. You have is funds to pay, so you're making payments. Do you have a payment?
I got $10.
Okay.
I'm gonna have more next week, because it's the first that I got my disability now.
Okay, I'll put you on for September 4th. See the clerk to make your payment, September 4th, 9 o'clock.
Thank you, sir.
You're welcome. Denise Sexton, 24-538. And you've got a certificate of completion with Thrive, so you need to get your community service done. You've been making payments on your bond. What about your community service?
My doctor clears me to go back to work in 2 weeks, so I should be able, yeah.
You can work here any day but Sunday, here at the court.
Okay. What time?
7:30. 7:30 to about 2:30. All right, September 4th will be your next hearing. 9 o'clock, September 4th. Cody Smith. Cody Smith is 22-2099 and 23-210. Has not appeared. And still has quite a bit left to do, so it'll be a bench warrant. Failure to appear. Okay, that finishes the reviews. Now we're going to start what are called the arraignments, or new cases or old cases with warrants that people want their warrants withdrawn or they got arrested on warrant. We'll call this all together. When your name's called, come up to the table to your right, stand there, and I'm going to go over the charge with you. Make sure you understand it. You don't have to agree with it, but you need to understand it. You have a right to remain silent. You don't have to say anything. But what we're saying here in open court is everything, even we're videoing everything. So there's a video, you saying whatever it is you say. So if you get up and admit something about your case, that could be used against you later by the prosecuting attorney who decides what the charges are. I don't decide what the charges are. That's the job of the prosecutor. So they may not be true. I don't make those decisions. I make the decision after the charges are filed. You have a right to have an attorney and to have one appointed for you if you can't afford one. You have a right to bail. You have a right to make the state prove the charge beyond a reasonable doubt. That's the highest standard of proof in law. If you enter guilty or no contest, you're waiving those rights that I just explained to you. You should not waive your rights if you don't understand your rights or if you don't understand what's happening. If you are confused, if you want to talk to a lawyer, if you want a trial, if you don't know what to do, not guilty is the plea you should enter under those circumstances. Call the first case.
State of Ohio versus Anthony Wills, case number CRP 26408.
Sir, are you Anthony Wills?
Yes, sir.
Have you received a copy of the charge?
Yes, sir.
Okay. It's a theft offense. It alleges that on May the 23rd of this year in Fayette Township, you purposely tried to deprive Lowe's of property without their consent. That's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. And then there's another charge of the same thing, but a different date, alleging June 7th, also there was a theft offense at Lowe's. Same possible penalty.
Mm-hmm.
Do you understand those two charges?
Yes, sir.
Do you understand the rights I explained defendants have?
Yes, sir.
How do you wish to plead to these charges?
Not guilty.
Do you want a lawyer appointed to represent you?
Yeah, I can see if I can, like, get a public defender because I, like, do little side jobs and work under the table here and there. So I don't know if I apply for one.
Okay, well, I have to determine your eligibility, and one of the things our Supreme Court tells me I have to do is determine what your gross annual income is.
All right.
You know what your gross annual income is?
Not really. We'd have to go over it.
Okay, what do you make in an average week?
I mean, here and there, maybe 500-600.
Do you have?
But it's like hit and miss because it depends on homeowners and if they need work done.
Do you have children?
Yes.
Tell me about that.
I have an 11-year-old daughter. We have a 17 and a 16-year-old.
So you have 3 kids?
Yeah.
Okay, you're eligible then, based on your income and the family size, for court-appointed counsel. So I'm going to appoint Mr. Stratton to represent you, and he is here, so we'll get him in the courtroom and introduce you. I'm entering a not guilty plea for you.
And in my past, I was addicted to drugs in a different county, and I have had a couple failure to appears, but that is tied to my drug addiction. Just.
Do you think you have outstanding warrants now?
No, sir.
Okay. This is Mr. Stratton.
Hello, sir.
2 counts of theft involving Lowe's.
Okay.
Misdemeanor thefts. Yeah, I've got 2. 26408 and 407. Entered in, yeah, it is in the computer. Okay. So not guilty plea is entered. He can sign a $1,500 signature bond.
Okay.
Don't leave. I'll meet you at the lobby and tell you what you need to do. So is that
So
no
what dates
Yes.
we're looking at for pretrial?
Any date except the 24th and,
In August.
yes. We'll get the statement, we'll all kind of talk for a second.
About the 7th. 7th is not that bad yet.
Yeah,
August
that'll work.
7th. August 7th will be the next hearing. It'll be a pretrial at 10 a.m.
Okay, thank you, Your Honor.
He will need, you haven't been fingerprinted, sir? Did you go to the jail at all?
He did not.
Okay. The bailiff will bring you a form. You have to take it to jail and get fingerprinted. You won't have to stay there, but you gotta go there to get fingerprinted.
Thank you.
All right, thank you, Your Honor.
State of Ohio versus Keisha Conley, case number TRC 261282, A, B, and C, TRC 261285, 1283, A, B, and C.
All right, ma'am, and you are Keisha Conley?
Yes, sir.
All right, Ms. Conley, there's two case numbers here. Start with the earliest one first, 261282, A, B, and C. Alleges July 21st at 1:46 a.m. in Cary Township, you were operating a vehicle while you were under the influence of alcohol, drugs, or some combination of those things, and that you refused to take tests. That is a first-degree misdemeanor. It carries a maximum penalty of 6 months in jail, a $1,075 fine, and a 3-year license suspension. There is a minimum penalty on this offense, and the minimum is 3 days in a treatment program, $565 fine, and a 1-year driver's license suspension. You're also charged with driving 55 in a 25 zone. That's a non-jailable speed offense. Well, actually, it's a sure clear distance ahead, so there must have been an accident. So as you were driving at a speed which would not allow you to stop in a sure clear distance ahead, it still is a minor misdemeanor. Maximum penalty is $150 fine. And there's a lane violation charge. That's also a minor misdemeanor. Maximum penalty is $150 fine. Then the next charge is 26-1285. And this is July 21st at 4:14. So 3 hours later. It's alleged that you were operating a vehicle in Perry Township under the influence of alcohol or drugs or a combination and refused to take tests. Same possible penalties that I explained to you on the previous case. So you're charged with 2 first offense OVIs. You're also charged with driving under suspended OVI suspension because under Ohio law, if you refuse to take the test, you can get an automatic suspension that goes in effect immediately. So they're alleging you were driving after that suspension went into effect. That's a first-degree misdemeanor. It carries a maximum penalty of 6 months in jail, a $1,000 fine, and it also carries a mandatory 3 days in jail, $250 fine. That's the minimum penalty on that offense if you're found guilty. Also a lane violation charge, which is a minor misdemeanor, maximum penalty is $150 fine. So do you understand the charges that have been filed?
Yes, I do.
Do you understand the rights that I explained to defendants?
Yes.
How do you wish to plead these
Not
charges?
guilty.
Do you wish to be considered for court appointed as an attorney?
Yes.
Tell me about your circumstances. Are you employed?
Yes. I'm a nursery teacher, an infant and toddler teacher.
Are you, how do you get paid? By the hour or you have a salary?
By the hour.
How much per hour?
13.
How many hours a week?
40.
Do you have any dependents?
No.
Okay, you're eligible based on your gross income. You're still eligible. I'll appoint Mr. Smith to represent you. There's 2 OVIs here in the same.
Yes, sir.
deed, with both refusals. She has a bond up with Mr. Sowers.
Yes, sir.
I'll continue that bond.
Thank you.
Not guilty pleas are entered.
I did hear just, was it a urine test or breath test or refusal?
Refusal on both.
Okay, so we're not waiting for,
There's no test.
gotcha.
Setting pre-trials, I could do basically, the 10th is pretty booked up, but after, 10th and 3rd of August, so
I could do.
any other date in August I can do.
14th or 17th, Judge?
Let's do the 14th. August 14 will be the next hearing. It's going to be a pre-trial at 10 o'clock.
10 o'clock, August 14th.
Anything from the state?
No, Your Honor.
Okay, next hearing is August 14th, 10 a.m.
Appreciate it, Judge, thank you.
Thank you.
State of Ohio versus Christian Deal, case number TRC 261286.
And Sir, are you Christian Deal?
Yes, sir.
Mr. Deal, it's alleged on July 22nd at 3:02 a.m. Union Township, you were operating a motor vehicle under the influence of alcohol, drugs, or some combination of those things. And the state's alleging you submitted to a urine screen, so those go to a lab for testing, and it takes several weeks to get results. I don't have any results. It won't for several weeks.
All right.
It's alleged to be your first offense. So on a first offense, maximum is 6 months in jail, $1,075 fine, 3-year license suspension. There is a minimum that I'm not allowed to go below if you're found guilty. The minimum is 3 days in treatment, $565 fine, and a 1-year license suspension. You're also charged with having some sort of, well, it says rear, it's either a tail light or rear license plate light out on the back of the vehicle. That's a minor misdemeanor. Maximum penalty is $150 fine. Do you understand the 2 charges?
Yes.
Do you understand your rights?
Yes.
How do you plead?
Not guilty.
You want a lawyer appointed?
Yes.
You have a job?
No.
You have no income?
No.
I'll appoint Mr. Davenport. Mr. Davenport will be your attorney. Not guilty is entered. And there is a bond up. So that's continued. I'm setting hearings for August. Any date in August except the 3rd and 10th are pretty booked up already. So we'll take some other date in August. What's your schedule?
The 24th, please.
24th is good. August 24 will be the next hearing. It'll be a pretrial at 10 o'clock.
Thank you very much.
You're welcome.
State of Ohio versus John Music, case number CRB 26445.
Mr. Water, you're
Yes, sir.
representing Mr. Music.
Yes, Your Honor. Mr. Music contacted me yesterday, indicated that someone had told him that there had been a warrant issued and there was some new charge that he needed to appear for, so I told him to come up here today.
It was just filed as a domestic violence. You want me to read it?
No, I've seen it at this point. Yeah, I've got a copy of it. We waive reading of the complaint judge, waiving defects in the time and manner of service, enter not guilty plea.
Not guilty plea is entered.
Mr. Music, Judge, you may know this already. There is another matter pending that's scheduled in front of you on August 10th.
Want to put this with it?
If you don't mind.
Okay. All right. August the 10th will be the next hearing. It'll be a pretrial at 10 o'clock. He can sign a signature bond of $1,000. He will have to go get fingerprinted on this one. I don't think he was.
I'll have him go down today and do that.
And is there a protection order on this?
Yes, Your Honor.
Okay. Any problem for him to stay away from Hallie Music?
No.
Okay. So that'll be an order also for him to stay away, temporary protection order. Next hearing is August 10th, 10 o'clock.
Thank you, Your Honor.
State of Ohio versus Haley Bolts, case number CRB 26447.
Ma'am, are you Kaylee S. Bolts?
Yes, sir.
Bail's bringing you a copy of the charge. It is a theft offense from Walmart. It alleges that on July 22nd, Fayette Township, he purposely tried to deprive Walmart of property without their consent. It's a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, sir.
Do you understand your rights? How do you plead?
Guilty.
Guilty means you're admitting it's true. By doing that, you waive the right to have a trial, have a lawyer, and are admitting the charge is true. You understand that?
Yes, sir.
Okay. I'll accept your guilty plea, what I typically do on these, because I find a lot of people that are shoplifting have drug problems. So I'm going to have you do a urine screen. And then I'll deal with that depending on what the results are. So go out into the lobby, make a left turn, go to, looks like Taylor's going to help you find where you need to go. Go to a urine screen to probation department, and they'll send you back after we get the results, and I'll send you after.
Okay. Thanks, sir.
State of Ohio versus Corey Johnson, case number CRB 26446.
Sir, you Corey M. Johnson.
Yes, sir.
This is also a Walmart theft, I believe, the companion case, the last one. And the bail's bringing you a copy of the charge.
Yes, sir.
It alleges July 22nd of this year, you purposely tried to deprive Walmart of property without their consent. Maximum penalty is 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, sir.
Do you understand your rights?
Yes, sir.
How do you plead to this charge?
Guilty.
And that means you're admitting the charges are true, waiving the rights to a trial, and to have a lawyer. Do you understand that? I'll accept your plea, same thing then. With the previous person, you need to take a screen. I'll send you after you get the screen results. So go to the probation department, get a screen done, then come back in the courtroom.
Thanks, sir.
State of Ohio versus Katina Diane Smith, case number CRB 26448.
Bailiff's bringing you a copy of the charge, and it is a Walmart theft charge. It alleges July 22nd, Fayette Township, you purposely tried to deprive Walmart of property without their consent. Maximum penalty for that is 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, sir.
Do you understand the rights you have?
Yes.
How do you plead to this charge?
No contest.
No contest? No contest means I'm not admitting I'm guilty, but I'm not denying it either. And if you, judge, hear the evidence the state says they have against me, if you think that's enough to convict me, I agree you can find me guilty without a trial and without me having a lawyer.
Yes, sir.
Is that what you want to do?
Yes.
Okay. Do you have a report on this, Mr. Hill?
I do, Your Honor. This is from Deputy Atkins from the Lawrence County Sheriff's Office. On July 22nd, 2026, I was dispatched to Walmart in reference to a reported theft. Upon my arrival, Walmart Asset Protection had already detained the subject in the office. The suspect was identified as Katrina Smith. Walmart AP advised that Smith had been stopped on multiple prior occasions for failing to scan all of her merchandise while using the self-checkout. AP, and that's Asset Protection, stated that during those previous incidents, they allowed Smith to pay for the unscanned items rather than pursue criminal charges. However, they advised that Smith committed the same offense again on this date. AP advised that Smith intentionally failed to scan several items while using the self-checkout. She paid for only a portion of the merchandise before exiting the store, passing all points of sale without paying for the remaining items. The total value of the unpaid merchandise in her shopping cart was $210.73. Based on the investigation, Smith was placed under arrest for theft. Walmart issued Smith a trespass warning, advising her that she is no longer permitted on the property. Smith was transported to the Lawrence County Jail without incident. At the time of the incident, Smith had 2 small children with her. Their father responded to Walmart and took custody of the children prior to Smith being transported to jail.
Okay, Ms. Smith, and it's Katina, right, not Katrina? Yes. Katina, that's what we got on the complaint. Do you have any statement or explanation you want to make?
No.
Okay, go as I did with the others, and I do this because about 80% of the people that shoplift are dirty. I don't know that you will be, but go do a urine screen and we'll come back and do the sentencing after that.
Alrighty, my friends, we have reached that time where we must unfortunately call an end to the week. But I've had fun this week, and I hope you have too, and we will most certainly be back Monday morning at 9 a.m. Eastern, 6 a.m. Pacific, because I like to get up before the sun comes up. And honestly, I just like spending time with you guys. I said it yesterday, this is the coolest thing ever, so thank you so much. Appreciate all of you. Today's wisdom comes to us from Psalm 37:8. Refrain from anger and forsake wrath. Fret not yourself, it tends only to evil. So ponder that as you go enjoy your weekend, and I look forward to seeing you all on Monday. Take care. God bless.